We'll call the case. When we do, you come to one of the two chairs right there, and then we'll take care of your case. All right. Well, a lot of people are doing it by video. So we've offered that, still continues. It makes it a little bit easier for folks. Well, I find that it's easier for people who aren't able to break away from work, but they can go out in their car or just take a little bit of a breather. So that's what we figured should help folks. Okay. Teresa, who do we have virtually?
Ashley Barrero, Betty Bennett, Ethan Maxwell, Catherine Hudson, Scott Trout, and Stephen Booth.
Okay. Let's, you know what, I think I'll probably take Jasmine's case first. That way she can be on her way. So why don't you come on up? I'm going to call case of the people of the state of Michigan versus Jasmine Herr. Would the prosecutor please identify herself for the record?
Sarah Ballman on behalf of the people.
And Ms. Herr, if you would state your name for the record.
Jasmine Herr.
Is the computer screen on?
I can see you and her.
Okay. All right. Today's time and date set both for a show cause as well as, oh, I see. You needed to be here in person because you may have missed a court hearing. So let me take a look here. Ms. Herr, you're representing yourself. You're planning on representing yourself going forward?
I was actually thinking about hiring something because I'm now under the understanding that it might be a felony.
Not this one.
Okay.
This is not a felony.
Okay.
This is a misdemeanor, but it's not a felony. You can hire an attorney if you wish to do that, but we are right now just at a misdemeanor phase. Let me figure out.
Okay.
Teresa, this was set for a show cause. I'm trying to figure out why we did that.
Your Honor.
Yes.
She failed to appear for the pre-trial set for June 22nd.
Ah, why weren't you here on June 22nd?
I had a misunderstanding of the date. I thought it was a different date, so I called and she said that I had missed court. She said she didn't enter
The bench warrant.
the bench warrant, and she said that as long as I appear in person on today's date, she said.
Sounds like you need a better system of keeping track of your schedule.
Yeah, my phone was cracked. My grandpa just had purchased a new one, so now I can see and log into Zoom if necessary.
If you're unable to afford a phone, paper calendars still do exist and they still
actually
work.
Just got one in my purse.
Okay. All right. So I will take that explanation as being true. So Ms. Baumann, is there an offer for Ms. Herr to consider?
Yes, Your Honor. Despite her long record with DWS, we're offering DWS first.
Okay. Do you understand what that offer means, or would you like me to explain it to you?
Can you please explain that?
Yes. Let me first check with my staff, see if they can hear you. I can hear you, but we need to make sure that we're recording. Teresa, can you hear Ms. Herr okay?
Yes,
Can
I
you hear
can.
me?
Okay. Right, Ms. Herr, driving without a license is against the law. With your license is suspended. The first time that it happens to you, the maximum penalty, that doesn't mean that's what you'll get, but the maximum penalty is up to 93 days in jail and up to $500 in fines. Again, that doesn't mean that's what's going to happen. That just means that's the most that could happen. If you do it more than one time, second, then it's called driving license suspended second. The maximum penalty is up to a year in jail and up to $1,000 in fines plus court costs. The Secretary of State also punishes you because we're different branches of government. I'm the judicial branch, got the robe. The executive branch, which is Secretary of State, would also suspend your license for another length of time, not the courts, but the Secretary of State would. We don't have one after 2. So if this is your 10th, it's still second. If it's your 14th, it's still a second. However, if you have 14 seconds, then you might be looking at jail time because you won't change your behavior. The prosecutor said that if you wish, you could plead as if it's a first offense, meaning it would cut down the possibility of jail from 1 year to 93 days and cut down the maximum fines from $1,000 to $500. However, you may still have to have your car punished because if you're driving 2 times the driving license suspended within 7 years, I have to punish the car, which means you have to put it, either sell it or put a boot on it or somehow immobilize that car. So they're offering for it to be a first offense as opposed to a second offense. Do you understand the offer?
I do.
You do not have to accept the offer, but your options are this. You can accept the offer and have it for a first offense, or you can have a trial and have it be a second offense.
Okay, so if I'm not to accept it, it goes on.
It goes on. And the proof would be, police officer would come in, say they pulled you over, they would point to you, say it was you, and then we would bring in the Secretary of State driving record. You have a little bit of more of an issue, however, because you are on bond, probably in Mount Pleasant for some charges over there that took place in circuit court, which is a felony. This conviction may have some impact on that case. I have no idea. Typically not, if you're not doing the same types of things that you are charged with over there. So the decision is yours. How do you wish to do? What do you wish to do? Do you wish to accept the offer, or do you wish to reject the offer and go towards trial?
I believe I'll accept the offer.
Stand up, raise your right hand, and be sworn in. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, yeah.
All right, go ahead and have a seat. I've explained to you the offer. However, has anyone made any promises to you that you're relying on more than what we've talked about, or has anyone threatened you to get you to plead to this when you really do not want to?
No, Your Honor.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, Your Honor.
Are you testing for drugs and alcohol right now?
Through Mount Pleasant.
Okay. If you enter this plea, you will be waiving some rights. Those rights are the right to a trial by jury, or if you, the prosecutor, agree, I could listen to the case and hear the case as a bench trial, but there'll be no trial at all. Do you understand that?
I do, Your Honor.
You'll be waiving the right to remain silent and not have your silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Can you still hear her, Teresa? You need to speak up just a little bit.
I'm losing my voice, but yes,
I
Your
can
Honor.
hear, Judge.
You will be waiving the right to representation by an attorney, whether you hired one or I appointed one for you. Do you understand that?
I do, Your Honor.
You'll be waiving the right to confront your accusers, to call witnesses, and to testify. Do you understand that?
I do, Your Honor.
Okay. Understanding rights and waiving them are different. I believe you that you understand those rights. In order for me to accept your plea to the reduced charge, you would have to waive them. Do you waive those rights?
Yes, I do, Your Honor.
I'm going to show you on the computer screen the copy of the original documentation. It should be up there by now. You see it?
Yes. Yes, Your Honor.
As you can see, there's only one count because the prosecutor has offered a plea to a different count. We're going to pretend today that there's a count 2, which is the driving while license suspended first offense. So I know on this piece of paper there's only one count, but I'm going to ask you, how do you plead to count 2, which is the lower crime of driving while license suspended first offense? Do you plead guilty, not guilty, or stand mute?
Kind of confused me there. Okay, so the second one is the lower, correct?
That is correct.
Guilty, Your Honor.
On or about March 15th of this year, were you operating a motor vehicle on Eastman Avenue in the city and county of Midland?
Yes, I was, Your Honor.
On that day, was your license suspended?
Yes, it was.
All right. Have I complied with the court rule and had an adequate factual basis, Ms. Baumann?
Yes, Your Honor.
I believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in records of court as driving a license suspended first offense. The second offense notification will be dismissed. Ms. Baumann, was there any crash that took place in this case?
No, Your Honor. We have no restitution in this case.
Okay. Ms. Herb, going to go to sentencing. There's some limitations right now because these jails are still, even though the rest of the society is off of quarantines and that type of thing. They're limiting how many people can actually go to jail right now. But I gotta be honest with you. You have 21 different convictions. This would be a case, and if you do come back again, I will put you in jail. You have not done well. You have convictions dating back from 2003 as a juvenile all the way. Let me see. You missed 2004 and 5. Other than that, almost every single year, you're in trouble with the law. You get in trouble in Saginaw, you get in trouble in Mount Pleasant, you got in trouble in Midland, you got in trouble in Harrison, you got in trouble for all types of things. You're on probation now. I don't typically put people in jail for driving a license suspended, but if you get another one, I will, because you're not changing your behavior. This is your 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11th
Are you
time.
kidding me?
No, I'm not kidding. So in 2008 here in Midland, in 2010 in Midland, 2011 in Midland, 2014 in Midland, 2014 in Saginaw, so you had one in July of 2014 in Midland, October 2014 in Saginaw, December 2014 in Midland, December 2014 in Midland, 2018 in Ithaca, which is Gratiot County, 2019 in Lakeview.
Actually, the Lakeview one, I took a plea, and the prosecutor had told me that it wouldn't go on my driving record. It was a civil thing.
It is, and quite honestly, if you're really going to quabble over one of 21,
Yeah, no, I have no right
that
to,
is,
yeah.
it's terrible.
It's,
If you drive in Midland County again, you are going to jail. Do you understand?
I do, Your Honor.
Where do you live?
In Coleman.
You live in Coleman. How do you get around?
Usually it's my grandpa or my mom, but my mom's health is failing right now. So actually that's why I drove that day. I was taking her to the hospital, but it doesn't justify it by any means. But there's a lot of things that have happened recently that have changed my perspective quite a bit.
I hope so. Do you work?
I do. I just got hired in at Soaring Eagle Casino.
What do you do there?
Wait staff and the buffets, and then also the concerts. Yep, I just got hired in 3 days ago. Orientation's later today. I don't have any wait staff experience, but they were willing to hire me.
Okay. Whose car were you driving that day?
That was my mother's. And she would never let me drive, but she couldn't.
She was an
breathe.
emergency.
Yeah,
Wow.
she's got stage 4 and COPD, and she was bad. It was kind of a life or death situation, and I
understand why you would be driving. You have to figure out you've put yourself in an awful hole. So you're going to have to figure out in advance before emergencies happen, what will you do? You're very young, so you have an opportunity to turn this around, but this has not gone well at all. It's going to be the sentence of the court that you pay $75 crime victim rights fee, $50 state assessment fee. Fines could be as high as $500. Sounds like you're just starting a job. I'm not going to do that. It's going to be $250. Court costs could be as high as $475. I'm not doing that either. It's going to be $250. And I am going to have you give back to the community. It's going to be really tough for you, but I want you to do, over the course of the next 6 months, 100 hours of community service. I have a community service coordinator. You're going to have to figure out how to do that. That's 5 hours for every, well, let's see, you got 11 of these. So it's 10 hours for every time you were driving a license suspended. If you're caught again, you give me no choice but jail. You have 21 days to appeal the sentence, 14 days to request court-appointed attorney to do that. You have a telephone number where my staff can contact you regarding your community service.
I do.
What is that?
It is 989-259-0734.
All right. All right. You're free to go now. You need to make a payment or yes.
I'm sorry. Is there a time limit when those need to be completed? Those?
Yes. I'm going, let's see. So it's 26 weeks. 180 days. So it's basically 100, it's 26 weeks. So it's 4 hours a week. You have to figure out how to do it.
Also, Your
So-
Honor, be immobilizing the vehicle.
Yes, I have to penalize the vehicle. If your mom would not let you drive except for an emergency, she's going to have to file a innocent owner petition. So that's
Innocent
over.
owner petition.
Yes, that you can get a copy of that. Barbara, is there anyone over to the probation department to get the innocent owner petition form I could send Ms. Her over to?
Your Honor, what we'll do is we'll run the play to who it is and the address on file. We'll mail it out
Okay.
to whoever the
mom's getting-
vehicle's registered to.
I presume your mom has it registered to her, the Secretary of State.
Is it registered to her or is it? Okay, yeah.
Yeah, so your mom's going to get a note. She's not feeling well, so keep an eye out for Secretary of State.
Okay,
She has to fill out that paperwork and then she can appear by Zoom. She doesn't have to come
okay,
in.
yeah, because she can't really.
Yep, she can come in. And then if I find that she would not have let you drive except for a medical emergency, then I may not have to punish the car. But if she doesn't do anything, then the notification's going to go. And if anyone's driving that car, they'll pull it over and take it in the impound. You have 21 days to appeal the sentence, 14 days to quit court appointed attorney. Please go over to the criminal window, make your payment or payment plan. Will be adjourned on your cases. Thank
Okay.
you, Ms. Herb.
Thank
Oh.
you. Have a lovely day.
I hope you really have made those changes. You've done a lot in the negative direction. Let's turn this thing around.
Absolutely.
Okay, thank you.
Have a good day.
All right, I see Ms. Bennett here, so we're going to call that case. Calling the people of the state of Michigan versus Betty Jean Bennett, file 210615 ST. Would the lawyer please identify herself for the record?
Sarah Ballman on behalf of the people.
All right, Ms. Bennett, if you would please unmute your phone or computer. If it's a computer, you hit the space bar. There we go. Can you say your name, please?
Betty Bennett,
Ms. Bennett, you're representing yourself. Is that correct?
yes.
Okay, Ms. Baumann, is there an offer for Ms. Bennett to consider?
Right now, the offer is to plead guilty with just the recommendations of fines and costs and restitution.
Do you happen to know what the restitution amount is?
Yes, it's $125.16.
All right. Ms. Bennett, did you understand the offer or would you like me to explain it to you?
I think I remember it.
Okay. You do not have to accept the offer, but if you wish, you can enter a guilty plea to the charge or have a trial on the charge. What do you wish to do?
Guilty,
All right, raise your right hand where I can see it. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
yes,
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this charge when you really do not want to?
no,
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
no,
I'm going to show you a copy of an advice of rights form, and I'd like you to tell me when it is on your computer screen. It should be there about now.
well, mine's just a phone, so it's really small.
Ah, all right. Well, I'll go ahead and go through the rights. So if you enter this plea, you'll be waiving some rights. Those rights were outlined on that form, but I'll go over them with you on the phone, on your phone. You would be waiving the right to a trial. You could have had a trial by jury, or if you and the prosecutor agreed, I could have listened to the case as a bench trial. There'll be no trial at all. You'll be waiving the right to representation by an attorney, whether you hired one or I appointed one for you. You'd be waiving the right to remain silent, not have your silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, to call witnesses, and testify. Do you understand each of these rights?
Yes,
You would have to waive these rights in order for me to take this plea. Do you waive these rights?
yes, I do.
Okay. How then do you plead to an accident to fixtures? Do you plead guilty, not guilty, or stand mute?
Guilty,
Take a look. On or about May 10th of this year, were you driving your Dodge Avenger on South Alamando Road, Greendale Township, Midland County, Michigan?
yes,
Did you run into somebody's mailbox?
yes,
Did you damage their mailbox?
yes,
Did you go up to the house and tell them that you damaged their mailbox?
no, I had so much glass down in my clothes, I had to go get stuff off.
And you didn't call the police either.
No, I didn't. I was just scattered. I was in shock.
Okay. Have I complied with the court rule and had an adequate factual basis, Ms. Baumann?
Yes, Your Honor.
I believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately will enter in as a failure to report an accident to fixtures. You said $125.16?
That's correct, Your Honor.
Okay. All right. Ms. Bennett, what would you like me to know before I sentence you in this case?
Nothing, I guess.
Are you working now or not?
No, I'm on disability.
What did you used to work?
Not for quite a long time, I haven't.
What did you used to do?
Well, I was doing home health care.
Home health care. Okay. So, when you did home health care, did you help people who sometimes had to take medications?
Yes.
You ever have a situation to where when you would go in and try to help them and you take a look at their pills and like they should have had like 10 pills left and all their pills were gone?
Oh, yeah.
And what do you think happened with all those pills?
Oh, the one guy I know, his son and daughter-in-law took them.
Right. So somebody stole them. But it could have been that they just had an accident and dumped their pills on the ground and didn't want to eat dirty pills, right?
Well, yeah, I could.
But you're pretty sure somebody took them to get high, right?
Yeah.
Okay. In my world, it works the same way. So when people crash into things and they don't stick around, you know what the law enforcement, what the judges think?
Maybe I had something to hide.
Right. What do you think that we think you may have something to hide? What do you think it might be?
Alcohol, drugs. I don't.
Yeah, that you might have been drunk driving. And in fact, you've had two drunk drivings in the past. That's the reason why the prosecutor's office wouldn't do that. But it doesn't look like you've been in trouble since 2015. True?
True.
Okay. Well, next time, it looks like it says here you swerved to miss a deer. And if that's true, you got to call the police. Otherwise, people think you're drinking and driving when you weren't.
Yeah.
All right. Well, it'll be the sentence of the court that you will pay $125.16. Ms. Baumann, could the victim rights people send over to the courts the name of the victims and the address so that we can get that as opposed to putting it out here on the record?
Yes, Your Honor.
All right. So $125.16 to the victim. You're going to pay $75 crime victim rights fee, $50 state assessment fee, and $100 in fines. I'll order no court costs because you're on disability and I want to make sure the victim gets paid. So 125.16 plus 100 plus 125. You owe $350.16. I'm guessing that you are on fixed income.
Yes.
Okay. So it's going to be hard for you probably to pay that $350.16 right now.
Right.
Well, if I give you 10 months to do that, that would be $35 a month. 1 month you're going to have to pay 16 cents. You think you could pay $35 a month if we started it out in August?
Yes.
Okay. Here's what I'm going to do. I'm going to pick a date that should be important to you. Does November 16th hold a special date in your heart?
It's my birthday.
Yes, it is. So 16th of every month. You can pay it before then. So if you get your money at the 1st, if you pay it before the 16th of every month, you're good. But I'm going to hold your birthday as the date that so that if we spot check to see if you're paying, I'm going to check to see if it's 16th, see if you made a payment. So your first payment date is going to be in August 16th. Again, you probably get your money in the 1st or the 3rd. As long as you pay before the 16th, you're good to go. You understand?
Yes.
I'm going to give you a telephone number I'd like you to call and make your payment plan with. Do you have a pen and paper?
Yep.
989 832
Yep.
6709. You're going to
Okay.
talk to Miss Shelley Peters and tell her your payment plan and make sure you follow up on your promises.
Yep, I will.
All right. You have 21 days to appeal the sentence, 14 days to request a court appointed attorney. Otherwise, we're going to be adjourned on your case. Thank
Okay.
you.
Mhm.
Who are we bringing in next? Looks like Mr. Booth is here, so we'll go with that one. It's People of the State of Michigan versus Stephen Aaron Booth, file 210658 SM. Would the prosecutor please identify herself?
Sarah Ballman on behalf of the people.
All right, Mr. Bennett, you can go ahead and leave now.
How do I get out of this?
We'll take care of it. Teresa, could you just end the session for Miss Bennett? Thank you. Mr. Booth, are you with us?
Yes, sir.
Please state your name for the record.
It is Stephen Booth.
All right, Mr. Booth, you're representing yourself. Is that correct, sir?
Yes.
Okay. Ms. Baumann, is there an offer for Mr. Booth to consider?
Yes, Your Honor. The offer is to plead guilty with a 6-month delay to dismissal if no further issues with the dog. Last time we were in court on his arraignment, there was some confusion with magistrate whether or not had like what the definition of owner was, because Mr. Booth had stated that it was his son's dog. We have, reaffirmed the definition of owner, and it's anyone who keeps or harbors the dog in their care or allows them to be permitted on their premises or occupied by him. So Mr. Booth does consist, he is consistent with an owner for the charges.
So it could be legally the owner, even though he's not the owner who went and got the dog or registered the dog.
Correct, Your Honor.
Okay. So, Mr. Booth, do you understand the offer, first of all? Or would you like me to explain it?
No, I think I understand it. It's like after 6 months, it just goes off, but you still got to pay the fine.
That's correct. And the dog, if the dog gets out, it doesn't go off your record. So,
Okay, we don't have the dogs anymore. We put them up for adoption.
okay. Well, it sounds like then that is probably low probability of violating. So yes, you would plead guilty. It would be on your record. And after 6 months, it would go off your record. It would be dismissed. You do not have to accept the offer, but your choice is, if you do not, and you enter the plea, if it goes to trial, then it doesn't get a chance to go off your record for 3 years because of the way the laws work. So it's up to you. What do you wish to do? Do you wish to have a trial or do you wish to plead?
I can just plead.
Okay.
I tried to plead before, but they wouldn't let me.
Got it. Okay. So I'll probably ask questions a little bit differently. I think the magistrate was concerned about whether or not you were the owner because you said your son was. So I'll ask the questions a little bit differently this time and see if we can get there. So I cannot see you, but I'm going to trust that you're telling me the truth. If you could please raise your right hand. Mine is in the air. Let me know when yours is.
Yes, it is.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this charge when you really do not want to?
No.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you at this time?
No.
If you enter this plea, you would be waiving some rights. Those rights are the right to a trial by jury, or if you and the prosecutor agreed, I could have listened to the case as a bench trial, but there'll be no trial at all. Do you understand that?
Yes.
You'll be waiving the right to have an attorney represent you, whether you hired one or if you qualified, I could have appointed one for you. You'd be waiving the right to remain silent, not have your silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, to call witnesses, and to testify. Do you understand each of these rights?
Yes.
If you enter this plea, you would have to waive those rights. Do you waive those rights?
Yes.
How do you plead to having a stray dog on or about May 19th of this year? Guilty, not guilty, or stand mute?
Guilty.
On or about May 19th, were you living at an address at 20 Welch Drive in the city and county of Midland?
Yes.
In your home, Was there a male brown and white boxer named Thor?
Yes.
On May 19th, on or about May 19th, did Thor get away from your home so that it was over at the neighbor's property?
Yes.
And at that time, Thor was not on a leash, as far as you know, or in a cage or fenced in. Is that true?
No. Yes, he jumped through the screen of the window.
He jumped through the screen of the window, so he was out of your house and out in public.
Yes.
Okay. And you're the owner of the home. Is that true?
Yes, I am.
Okay. Have I complied with the court rule and had an adequate factual basis, Ms. Baumann?
Yes, Your Honor.
Believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately will enter in as conviction for a stray dog. Ms. Baumann, was there any restitution that was owed? Did Thor do any damage?
No, Your Honor, there's no restitution.
Okay. So, Mr. Booth, I'm guessing that you had a talk with your son regarding his dog and the troubles that his dog has caused you.
Yeah, he's got a girlfriend, so we don't really spend much time with him. So I told him to take him down to the Humane Society and get him adopted out. So that's what he did.
Okay. Well, it sounds like he's followed the rules. All right. Well, based upon that, and there's no other restitution, I'm going to send you this way. The statutes say I must send you to $75 crime victim rights fee and a $50 state assessment fee. The fines could be between $10 and $100. I'm doing $10 because it sounds like it really was your son's dog rather than yours, and it doesn't sound like this is a perpetual problem, and you have no prior criminal history. I'm not going to charge you any court costs. I'm going to keep the fines and costs very low, so it's $135. I'm going to place you on 6 months of non-reporting probation. The terms of your probation are don't violate the law. So, as long as you don't get in trouble in any way, shape, or form in the next 6 months, which includes if you happen to get another dog, if the dog doesn't get strayed and go off your property, then in 6 months, this will be dismissed. You have 21 days to appeal the sentence, 14 days to request a court-appointed attorney. I would suggest, sir, if you paid $135 as soon as possible, and all you got to do is just wait out the 6 months.
Okay.
All right. Anything else we need to place on the record in this case, Ms. Baumann?
No, Your Honor.
All right, we'll be adjourned. Thank you, Mr. Booth.
Thank you.
I see Ms. Barrero.
Yes.
We're going to call that case. We're calling a case of the People State of Michigan versus Ashley Barrero, file 21-0690 ST. The prosecutor, please identify yourself for the record.
Sarah Baumann on behalf of the people.
All right, Ms. Barrero, if you would state your name for the record.
Ashley Lucia Barrero.
All right, today's time and date set for pre-trial. Ms. Barrero, you're representing yourself. Is that correct?
Yes.
Ms.
Baumann, is there an offer for Ms. Barrero to consider?
Yes, Your Honor. We are offering DWS first, but we're not presuming that there won't be any jail here because there's so many priors with Ms. Barrero. So we take that presumption off on our end.
Okay. Hang on, let me pull up Ms. Barrero's criminal history. Ms. Barrero, you have 14. You have 14 different charges. Almost all of them are driving while license suspended. So the prosecutor is saying you could plead to a first offense. They would dismiss the second offense. They also know that I understand people make mistakes, but I expect them to make different mistakes and learn from their mistakes. So after a while, though most people don't go to jail for driving license suspended, it's a possibility that you could because of how many you've had. Based on our circumstances, I'm probably not going to do that, but I might have you do another punishment instead. But the prosecutors are offering to reduce the charge from a second offense to a first offense. Do you understand the offer?
Yes.
You wish to accept the offer?
Yes.
Raise your right hand and be sworn in, please. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No,
Are you under the influence of any medicine, drugs, or alcohol that's confusing you?
no,
If you enter this plea, you'll be waiving the right to trial. You could have had a trial by jury, or if you and the prosecutor agreed, you could have had a bench trial, but there'll be no trial at all. Do you understand that? You'd
Yes.
be waiving the right to counsel. You could have hired an attorney, or I could have appointed one for you if you qualified. You'd be waiving the right to remain silent, not every silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, call witnesses, and testify. Do you understand that?
yes,
You would have to waive these rights in order to enter this plea. Do you waive these rights?
yes,
How do you plead to an added count 2 of driving license suspended first offense? Do you plead guilty, not guilty, or stand mute?
guilty.
On or about May 21st of this year, were you driving a motor vehicle on Bay City Road in the city and county of Midland?
Yes, yes,
On that day, was your license suspended?
yes,
Ms. Baumann, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
I believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter as count 2. Driving a license suspended first. Count 1. Driving a license suspended second will be dismissed. Ms. Baumann, is there any restitution that needs to be done for this case?
No, Your Honor.
All right. Ms. Barrero, whose car were you driving that day?
my mom's van.
Did your mom know that she could lose her van and have to sell it or have it immobilized because you were driving it?
No, I didn't know that either.
You living in Midland now?
Yes,
Do you work?
yes.
What do you do?
I'm a caregiver at Bay Comfort Care.
How do you get around and get to work because you don't have a driver's license?
My mom drops me off and picks me up.
Do you have children?
Yes,
How do they get to school?
the bus.
Okay. How old are your children?
18, 17, and 12.
Okay. Without saying which child, have any of them ever disobeyed a rule you've had?
They're little kids. Not really. I got pretty good kids.
Yeah, but I gotta think at some point in time, one of them didn't call when they were supposed to, or one of them didn't show up when they were
Yes,
supposed to.
they don't always listen, but they're pretty good.
They're pretty good, but on occasion they would mess up, right?
Right.
I was gonna say, there's no perfect kid, although it sounds like you got pretty close to it. But what if 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11? What if you told them to clean their room up 11 days in a row and they just didn't do it? How would you handle that? You got good kids, so you're a good parent. How would you handle that? You say, clean up your room. They okay. Next day, room's a mess. Clean up your room. Next day, room's a mess. Clean up your room.
I take
Next
their
day.
phones and their games away.
Okay, what if that didn't work? What would you do then?
Ground them.
What if that didn't work?
I don't know.
Right. But you would change things, right? It makes no sense. If you take their games away and they still don't clean up their room, wouldn't you change what you would do to get them to change?
Yeah.
I mean, you just said that. You very quickly. So it tells me you're probably a really good mom. I mean, you understand, you pay attention to your kids, you know what makes them work. And I got to think between your 18, your 17, your 12-year-old that they, even though they're all good kids, I bet you their personalities are all different.
Right.
And you probably got one kid that if you look at them sideways, they melt down. You got another kid probably that's reached by, if you take their game away, and you probably got another kid that if you just tell them they can't be around their friends, something different has to reach each kid because they're not the same person. Would you agree?
Correct. Yes.
11 times Saginaw tried to use money. It didn't work because you keep driving.
Well, yeah, because I couldn't afford it at the time. We had those driver responsibility fees. It was just a lot.
But they got waived. They got waived.
Yeah,
All
in the
of them.
beginning, and I couldn't afford them.
Yeah, and yet you're still driving. Then you missed court 12 times, it looks like. from the Secretary of State. So here's what I'm telling you, Ms. Barrero, I'm going to try something different. And then if you don't do what I tell you to do, then I'm going to try something else different. And eventually it could end in jail. So here's the sentence. Be $75 crime victim rights fee, a $50 state assessment fee, $250 in fines, $250 in court costs, and you're going to do 100 hours of community service within a 6-month time period. That means about 2 to 3 hours a week. And so you're going to have to get that done within a 6-month time period. And if you don't do that, what you've told me is taking away your games don't work and grounding doesn't work. So you're going to end up in jail if you don't do these community service hours. You're going to give back to the community you've been taking from, although it's mostly sagging off the driving license suspended. You've been very good here in Midland, but nonetheless, you're going to have to give back, which means that your mom is going to have to take you around. But the problem is I have to punish the car. So I have to order that the car must be immobilized unless your mom can show me through an innocent owner petition that she didn't know your driving license was suspended. That's going to be hard for me to figure it out. And she didn't know you were driving the vehicle, but the vehicle has to be punished. So I'm ordering the mobilization for the vehicle. So now realize your mom could end up losing her wheels as well because you drive her vehicle. Do you understand?
Yes.
Okay. You have 21 days to appeal the sentence, 14 days to push the court appointed attorney to do that. You're going to have to make contact to get those community service hours done. You got half a year to get those 100 hours in. We'll be adjourned.
Okay, so where is there a certain place I have to go, or
Barb, how are we going to reach out to her?
Ashley, does your phone number end with 7459?
yes?
And let me see if we have an email for you. And your email is your first last name, 86. Okay, we'll contact her either through phone or email later today.
That sounds great. Let's make sure we get it done, Ms. Barrero. That's the equivalent of taking your games away. Okay?
Okay. Okay.
Don't make me step it up. We're all set for today. Thank you.
All right.
All right, we're going to call the case now of People's State of Michigan versus Catherine Elizabeth Hudson, file 210581ST. Counsel, identify yourself for the record.
Sarah Ballman on behalf of the people.
Hudson, if you would please state your name.
Catherine Hudson.
All right, today's time and date set for pre-trial in this case. Ms. Hudson, looks like you're representing yourself. Is that correct?
Yes, sir.
Ms. Baumann, is there an offer for Ms. Hudson to consider?
Yes, Your Honor. Currently, the offer is that if she has a valid proof of her license, or her license is valid, then she can admit responsibility to a citation for failure to stop at the stop sign and be good from that.
Okay. Deb, do you see whether or not her license is valid?
Sir?
It appears that she only has state identification at this time.
Okay.
No.
Yes, Ms. Hudson?
I have, excuse me, but I do have my permit. I just got it yesterday.
You got your driver's permit?
I have my driver's permit and I have an appointment Friday morning with Yates at 10 a.m. to do my driving test. And then I'll be all set, they told me.
Okay. Ms. Baumann, I think what I'll do is I'm going to adjourn this then. If that offer for her to have a driver's license, we want her to. If you just never had a license, Ms. Hudson?
No, actually 27 years ago, I got in a bad car accident and I decided I just didn't want to drive. And the only reason I was driving this time is because I had a 12-year-old Yorkie that was dying and I had no way to get my husband because he's a truck driver. And the road out here is a restricted road. So I didn't have no choice. I didn't feel anyway. And I got him the vehicle that sits at our house and I drove my husband's vehicle to go get him. And I was like only 3 miles from the house when I got pulled over. And I was totally honest with the officer what was going on. And he could tell I was in a lot of distress at that point. And I did lose my little Yorkie the following morning.
Oh, I'm sorry about that. Well, here's what we're going to do, Ms. Hudson. We want you to follow through with getting that license, because if you ever have another situation, if your husband's not at home, you probably should have ability to get to places. So I'm going to set this over for 30 days so that you can get your license. And at that point in time, Ms. Baumann, would the offer still be available?
Yes, Your Honor.
All right, so what they're planning on doing is dismissing the criminal charge and let you admit to a civil infraction, which is a good offer, but you need to do some work first. So let's give you a new time and date. You can do it just like this by Zoom. Teresa, do we have another time and
Okay.
date?
Your Honor, that would be August 31st at 8:15.
All right, so you got a little bit more time than that. So you got 6 weeks. So August 31st at 8:15, jump back on Zoom and let's make sure you get your driver's license set, okay?
Yes, sir. I will.
Deb, how much is failing to stop at a traffic sign, the citation?
I'm sorry, Your Honor, it's 135.
All right, so make sure you also have $135 at your disposal because that's going to be your citation when the case is dismissed. Presuming you get your driver's
Yes,
license.
sir.
So good luck on your driving test. They make people nowadays have to do parallel parking. They didn't have to do that when I was trying to get my license. So practice that up.
Thank you. I know how to do that.
All right, wonderful. All right, we'll be adjourned. Thank you.
Thank you.
I see Ethan Maxwell here in the front screen, so we'll call Maxwell's case. So this is the People's State of Michigan versus Ethan Maxwell, file 210573SM. Would the prosecutor please identify himself for the record?
Sarah Ballman on behalf of the people.
And Ms. Maxwell, if you could please unmute yourself and identify yourself for the record.
I'm Ethan Maxwell.
All right, today's the time and date set for a pretrial. Mr. Maxwell, you're representing yourself. Is that correct?
I wanted a court-appointed attorney.
Okay. Did you ask for one earlier?
It was never brought up to me, and it was never offered to me.
Never brought up to you and never offered to you.
Yeah, I had
Are you working?
Not right now. I'm actually switching jobs.
How old are you?
I'm 17.
You're 17. So do you live at home with your parents?
Yes.
Okay. I'll give you a court-appointed attorney. I'd like to set this out. I think if he's 17, we're going to have an issue come the fall because the raise the age changes in October. So let's do a pretrial out August 31st, and let's see if whether or not we need to transfer this case down to probate court.
Okay.
August 31st at 9 o'clock will be your, do we still have 9 o'clock slots? Teresa?
We do, Judge. Yes, we do.
All right. August 31st at 9 o'clock, your attorney will get in contact with you regarding where this case is going. Okay?
Okay.
All right. Bond will be continued. We'll be adjourned. We're all set for you today, sir. I see, looks like Mr. Trout is here. So calling the case of the People's State of Michigan versus Scott Douglas Trout, file 151352ST. Would the prosecutor please identify themselves for the record?
Sarah Ballman on behalf of the people.
Mr. Trout, are you there? Can you hear me?
Yes, Your Honor, I'm here.
Okay. Could you state your name for the record?
Scott Douglas Trout.
All right. Today's time and date set for a pretrial. Mr. Trout, you're representing yourself. Is that correct?
Yes, Your Honor.
Ms. Baumann, is there an offer for Mr. Trout to consider?
Yes, Your Honor. The offer is to plead guilty to allowing DWS if he has a valid proof of his license.
All right. Deb, did we run Mr. Trout's license to see if he's valid?
I am valid, Your Honor.
Great.
You're- I'm sorry, we did run him and he is valid.
Okay. So, Mr. Trout, the prosecutor is offering to let you plead to a reduced charge of allowing another person to drive while license suspended. The advantage of that charge is that you don't lose your driver's license as a result of the conviction. You could reject that and have a trial, but the trial would be based upon the original charge of driving license suspended second offense. And if you lost that trial, you would lose your driver's license again. So it's up to you. Do you wish to enter the plea as offered, or do you wish to have the trial?
I plead guilty to the offer, Your Honor.
All right. Well, because I can't see you, we have to go through a few steps first. I'm going to trust you
Yes,
telling
sir.
me that my right hand is in the air. Is your right hand in the air?
It is, sir.
Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, sir.
Are you under the influence of any medicine, drugs, or alcohol that's confusing you at this time?
No, sir.
If you enter this plea, you'll be waiving the right to a trial. You could have had a trial by jury, or if you and the prosecutor agree to trial by judge, there'll be no trial at all. You'll be waiving the right to representation by an attorney, whether you hired one or qualified for a court-appointed attorney. The right to remain silent, not have your silence used against you. The right to be presumed innocent until proven guilty beyond a reasonable doubt. And the right to confront your accusers, call witnesses, and testify. Do you understand each of these rights?
I do, sir.
Do you waive these rights to accept this offer?
Yes, Your Honor.
How do you plead to added count 2 of allowing another person to drive while their license was suspended? Guilty, not guilty, or stand mute?
Guilty, Your Honor.
The law lets me take a factual basis based upon what you did and enter it in as the offer. So I do not think you let somebody else drive. I think you drove. So I will ask you questions about what you did. On July 23rd, 2015, were you driving on Lyon Road in the city and county of Midland?
I was, sir.
On that day, was your license suspended?
Yes, sir.
All right. Have I complied with the court rule and had an adequate factual basis, Ms. Baumann?
Yes, Your Honor.
Believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in records of the court as allowing another person to drive a license suspended. Count 1, driving license suspended. 2nd will be dismissed. Was there a crash or anything we need to take into consideration for restitution purposes, Ms. Baumann?
No, Your Honor.
All right. Mr. Trout, looks like there's a saying that says, by perseverance, the snail made it to the ark, and it looks like you got this case resolved. It's been 6 years. You could have gotten a master's degree in the amount of time that you had this charge. So I don't know what took you so long, but I'm grateful that you took care of it. So I'm going to sentence you this way. It will be $75 crime victim rights fee, $50 state assessment fee, $125 in fines, $125 in court costs. Now that's $375. You'll need to pay that. Do not compound your errors, because if you do not pay it, at the present time, you could lose your driver's license for not paying. The law changes in October, but make sure you pay it.
I will pay that today, Your Honor.
All right. Let me give you the telephone number so that you can call and make that payment. Are you ready?
Yes, sir.
989.
Yes, sir.
832.
832, sir.
6718.
6718. Thank you, sir.
Yeah. Yes, you have 21 days to appeal the sentence, 14 days to request court-appointed attorney to appeal it. Otherwise, pay it, and it's done. Okay?
Yes, sir. Thank you very much, Your Honor.
Thank you. We'll be adjourned.
Your Honor, I need to bring in a couple of them to see who they are in the waiting room.
Why don't you do that? I'm going to step off for just a minute. Stretch my legs.
Am I all done, ma'am?
Yes, you are.
Thank you. Have a nice day.
You too. The person with the phone, Beth K. Can you tell me your name, please? Can you tell me your name, please, sir?
Gerald Brower.
He's with me for an 845 settlement.
Okay, thank you.
Looks still all right here.
Okay, Mr. Brower, I'm going to put you back in the waiting room and we'll be right with you, okay?
All right, thank you.
Can you hear me, sir, with the Galaxy 10? One, can you hear me, sir? With the Galaxy? Can you hear me, sir? With the Galaxy 10, can you hear me? Sir, with the Galaxy 10, can you hear me? Sir, can you hear me with the Galaxy 10 phone?
All right, we have three real quick at 8:15. I'm just going to call. This is the People of the State of Michigan versus Daniel Hall, file 210477ST. Prosecutor, please identify yourself for the record.
Sarah Bauman on behalf of the people.
Teresa, is there anyone named Daniel Hall in the virtual waiting room? You're muted.
No, Your Honor, there is not.
Do we see anybody out in the lobby, or there's no one in the courtroom with me?
I will check the lobby real quick.
I can check it.
Okay.
I see no one in courtroom B, no one in the court office area, or in the lobby, or coming in the hallways, or coming up to the courthouse. So this is the time and date set. It was actually set for 8:15 this morning. Notice was sent to Mr. Daniel Scott Hall, 3303 North Garfield Road, Peconic, Michigan, 48650 on June 17th, notifying him to be here. He has failed to appear. The defendant has not appeared in court. Checking his record, he has failed to appear before. He had a 48-hour bench warrant, so this will be an immediate bench warrant because he has already benefited from the new statute allowing him to show up within 48 hours. Bench warrant will issue. His bond will be set aside, will be adjourned. Next file is the People of the State of Michigan versus Kate Marie Murphy, 210640 SM. Prosecutor, please identify yourself for the record.
Sarah Bauman on behalf of the people.
Today's time and date set for the pretrial in this case. Teresa, is there anyone in the virtual waiting room that could be Miss Murphy?
No, there is not, Your Honor.
All right. Notice was sent to Miss Murphy's home at 902 Jerome Street, Midland, Michigan. It was mailed to her on June 17th, notifying her to be by Zoom at 8:15. The time is 9:28. She has failed to appear. No one's in a virtual waiting room. There's only one individual who is waiting for another court function in the lobby, and therefore bench warrant will issue. Her bond is revoked. Let me see if she's had any. It does not. I do not see any prior opportunities to appear in 48 hours. This would be a 48-hour bench warrant at this time. I'll sign the order after 48 hours. Will be adjourned on her case. The last one for the 8:15 is People of the State of Michigan versus Andre Alexander, file 210535 ST.
Your Honor, he might be the
Yes.
Galaxy 10.
Yes, it's. Can you hear me?
I can hear you. Is this Mr. Alexander?
Yes, sir.
Oh, right. So would the prosecutor please identify themselves for the record?
Sarah Bauman on behalf of the people.
All right, Mr. Alexander, good morning, sir.
Good morning.
You're representing yourself, is that correct?
Yes, sir.
Ms. Bauman, is there an offer for Mr. Alexander to consider?
Yes, Your Honor. The offer is allowing DWS if he can provide his license is reinstated.
Okay, Mr. Alexander, is your license valid?
Yes, sir.
All right, Deb, have we verified that?
Your Honor, I'm showing that Mr. Alexander has a restricted driver's license.
Okay, is that sufficient enough, Ms. Bauman?
I believe so, Your Honor.
Okay, so Mr. Alexander, the prosecutor is offering you to plead to a charge that would allow you to keep your restricted driver's license. If you go to trial and lose, you would lose your driving privileges altogether again by the Secretary of State. You do not have to accept the offer, but if you wish, you could enter a plea to the reduced charge today. What do you want to do? Have a trial under the original charge or plead to the lower charge?
Plead to the lower charge if that's my best option, because I didn't know my license was suspended when they gave me the ticket. They were supposed to pay it.
Yeah, unfortunately, how this tends to work is that if the Secretary of State send notice to your home, you may not have physically known it, but there's something called constructive notice, meaning that as long as they sent the notice in time, and I don't know the facts of your case, that sometimes it passes in the mail, but those trials could go either way, but typically they're fairly easy for the prosecutor to prove. So it's up to you. I don't know the facts of the case that well to be able to advise you. And in fact, my job is to kind of be more like an umpire, not advising you one way or the other, just call balls and strikes. So as it stands now, what do you wish to do? Would you want to accept the offer?
Well, what's the offer?
It's against the law to drive when your license is suspended. It's against the law to let somebody else do it as well, if you know it. So let's say you got a brother named Bob. Bob doesn't have a license, and you know it. He comes to your house and he says, I'd like to go down to the corner store, get some ice cream. And you say, Bob, you don't have a license, but he keeps bothering you so much, you finally just toss him the keys and he drives, and guess what? He gets pulled over. He gets charged with driving license suspended, and you get charged with letting him. The difference between Bob's charge and your charge in that fictitious situation is that he loses his license again and you don't. You just get fines and costs or whatever the judge might do.
Oh, okay.
So the prosecutor is going to let you plead to the reduced charge of allowing somebody else to drive a license suspended. The law lets me take a factual basis based upon what happened and then enter it in as this reduced charge. You don't have to do that. The option is having a trial on the original charge.
All right.
So it's up to you. Do you wish to accept the lower charge, or do you want to have a trial on the higher one?
Well, I'll take the lower charge just so, because I don't.
You don't want to mess up your driving, your restricted license.
Right.
Okay. So I can't see you, but if you would tell me when your right hand is in the air, I'll swear you in.
Yes. My right hand's in there.
Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes, sir.
All right. You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record, or threatened you in any way to get you to plead to this when you really do not want to?
No, sir.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
If you enter this plea, you'll be waiving the right to a trial. You could have had a trial by jury, or if you and the prosecutor agreed, I could have listened to the case as a bench trial, but there'll be no trial at all. You're going to be waiving the right to an attorney helping you, whether you hired one or if you qualify for a court-appointed attorney. You're going to waive the right to remain silent, not have your silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, call witnesses, and testify. Do you understand each of these rights?
Yes, sir.
All right. You'd have to waive these rights in order for me to accept this plea to the reduced charge. Do you waive these rights?
Yes.
All right. How do you plead to an added count 2 to the reduced charge of allowing an unlicensed person to drive because their license is suspended? Do you plead guilty, not guilty, or stand mute?
Guilty.
On April 28th of this year, were you driving on East US 10 in Lincoln Township, Midland County, Michigan?
Yes, sir.
On that day, was your license in fact suspended?
Yes, sir.
All right. Have I complied with the court rule and had an adequate factual basis, Ms. Baumann?
Yes, Your Honor.
I believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in as allowing a driving license suspended. The original charge of driving license suspended will be dismissed. Ms. Baumann, was there any crash or any restitution I have to take into consideration?
No, Your Honor.
Okay. So, Mr. Alexander, I'm looking at the notes at the top. You were really bringing the mail that day. The police, that catches the attention of the local police when you have triple digits and speeding.
Yes, yes, sir.
Okay. Well, let's make sure this lighten up. Let's put that right foot of yours on a diet.
Yes.
Okay. I'm going to sentence you to $75 crime victim rights fee, $50 state assessment fee, $150 in fines, $150 in court costs. So that's $425. You're going to need to pay that. Otherwise, you could lose your license for not paying, but you do not lose your license because this is not abstracted to the Secretary of State. Are you able to pay that today, sir? Or do you need some time?
I need time.
Okay. If I give you 10 months, that's $42.50 a month. You think you can pay $42.50?
Yes, sir.
Why don't I pick a date that should be important to you? Let me see. Is February 19th, 1958 sound like a good day to you?
Yes, sir.
Okay. So on or about the 19th of every month, why don't you make your payments? You can pay it faster than that if you want, but I'm giving you 10 months to do it.
Okay.
All right, so let me give you a telephone number. I'd like you to call Miss Shelley Peters at this telephone number to set up your payment plan. Are you ready?
Yes, sir.
It's area code 989
989
832
832
6719.
6719.
Excuse me, I said that wrong. 6709.
6709. Okay.
All right, so if you call her and make your payment plan, again, you could pay it off faster than that if you wish, but you will have 10 months to pay it, $42.50 a month.
Okay. Thank
you. All right, you have 21 days to appeal the sentence, 14 days to request a court-appointed attorney. Otherwise, we're adjourned on your case, Mr. Alexander. Thank you.
Thank you.
All right, we'll be adjourned. You're free to go now.
Thank you.
All right, calling case of the People State of Michigan versus Gerald Dean Brower. This is file 21-0455SM. Counsel, identify yourself for the record.
Thank you, Patrick Swinsky for the people.
Peter Durant's on behalf of Gerald Brower, who is appearing via Zoom today.
All right, I show that we need to do an arraignment as well as settlement conference. Was there an additional charge that was added?
Some of the language was modified, Your Honor.
Filed amended wording. Okay, so let me take a look. The trespass portion of it. All right. Mr. Durant, have you seen a copy of the amended complaint?
Yes, Your Honor. If we're talking about the one where it's adds the agent of the owner language to the amended complaint? That is correct. Oh, yep. Then I have a copy of it right here.
All right. Do you need me to read that to your client, or is he familiar with the charges and the language in it?
If you wouldn't mind reading it to him, Your Honor, just so that he's completely aware.
Certainly. All right. So, Mr. Brower, I'm going to show a copy of a document to you. If you would let me know when it pops up on your computer screen. Should be there right about now.
Yes, Your Honor.
All right. So it looks like the charges didn't change. They charge you with assault or battery against the Larissa Ridman in count one. That didn't change. What changed here was the language in the trespass. So what they're doing now is changing the language to say that you did enter the lands or premises of Larissa Ridman without lawful authority after having been forbidden to do so by her as the agent of the owner and or the agent of the occupant. So I think that still makes it a misdemeanor punishable by up to 30 days and or $250 in fines. So I think what had happened, I don't read the police reports. I don't get them. But I suspect what had happened was they listed her as an owner, and she wasn't an owner, but she was working on behalf of the owner, so they changed the language to match the facts in the reports. Do you understand? I'm not asking you to plead at this point in time. I just want to make sure you understand the charges against you.
Pretty much, I was trespassing, but I never do the assault.
Okay, but you understand. So at this time, I'm still asking just if you understand what you're being charged with. That's all. Whether you agree with it or not is different, and we'll talk about that in a minute. I just need to make sure you understand what you're charged. Currently, you're charged with 2 crimes: assault and trespassing. I'm not asking you if you agree with it. I just want to know if you understood what you're charged with.
Yes, Your Honor.
All right, Mr. Durant, I think for arraignment purposes, I will enter a not guilty plea for your client on both counts. Would that be all right?
That's perfect, Your Honor.
Okay, so now we are at the settlement conference to try to figure out the case. Has there been an agreement reached in this case, Mr. Durant?
The previous offer was pleading to count 1 assault and battery, dismiss count 2 trespass. At this point, my client is not accepting that offer, and we would proceed forward to trial, which I believe is scheduled for this Thursday.
All right, Mr. Schwinski, is that still the offer?
It is, Your Honor, and we won't be modifying the offer, and we'll be prepared for trial on Thursday.
Okay, there is one trial that was currently ahead and will go if Ms. Weaver is available. That trial's going because it's significantly older than Mr. Brower's case. However, I don't see Ms. Weaver here, so it still will be going to trial. It's probably a safe assumption that this case will be the trial that will go. So, any issues regarding bond, Mr. Schwinski?
No, Your Honor, and I assume the court would like, obviously we don't know yet if this will be the trial, but it sounds like it's most likely will be. We'll have our jury instructions to the court by the end of business today.
All right, Mr. Durant, if you could do the same, I would appreciate it.
Of course, Your Honor.
All right, so we're going to, the jury has already been oriented, so we will have them appear at 8:30. Teresa, we'll have to let the other Teresa know, or who's filling in for her, that we'll have the jury appear at 8:30. If the attorneys could get here about that time to look over the final instructions, we'll merge between the two of your instructions to see if there's any overlap or any instructions that we don't, that you will look at the instructions while we're taking roll call with the individuals. So, Mr. Brower, if when you appear, Mr. Drance will tell you where you need to come and meet him at the courthouse. It'll be at the courthouse for the trial. Because we have a whole bunch of people that are on the potential jury, we need to keep the witnesses as well as you away from the jurors so that there's no view of impropriety. I don't think that you would do anything inappropriate, but it doesn't look good if you're sitting with the jury. So we want to make sure that you follow what Mr. Drance tells you to do and where to go and meet him, okay?
Yes, sir.
All right, we'll see you on Thursday. And Mr. Durant, we will let you know if Miss Weaver's case ends up going first, although she's not here right now and should have been here an hour ago. So it looks like your case will go.
All right, thank you.
All right, thank you. We'll be adjourned. I am calling the case of the people, State of Michigan versus Aubrey Rebecca Weaver, file 20-1121-ST.
Your Honor, I have a Dennis Newell in the waiting room. I'm not sure who that is. I don't have anybody with that name on the docket, so I'm going to bring him to make sure that's not her.
Okay. Is that the only person? Yeah, Mr. Brower, you're all set to go.
All right, thank you, Your Honor.
Did we lose that person?
I think we did.
All right, let's get the appearance of the prosecutor, at least for the Weaver case.
Thank you, Your Honor. Patrick Swinsky for the people.
All right, today's the time and date set for settlement on the Weaver case. This is file 20-1121. Ms. Weaver has been representing herself and demanded a jury trial, but has failed to appear. Let me take a look, see if there's anyone in the lobby. There's not. There's no one walking up to the courthouse, no one in the other courtroom, no one in the lobby, no one in the hallways. Notice to appear was mailed on June 8th. It was mailed to Miss Aubrey Weaver at 191 South Geneva Road, Shepherd, Michigan 48883. That address was mailed and it was not returned, and therefore the court believes that she was served. She was supposed to be here by Zoom at 8:45. The time is 9:44. So bench warrant will issue for her arrest. See if Ms. Weaver's had any opportunity before.
She did fail to appear for her arraignment, but that was back in October, I believe.
Okay, well, let's see. There's a bench warrant. Was returned on April the 29th, so she has had an opportunity. It will be an immediate bench warrant. Bond will be revoked. Will be adjourned. So that means that the Brower case is case number 1.
Thank you. We'll be ready.
Thank you. All right, we have 2, at least 1 pro per and 1 person in jail. So who are we bringing in next, Teresa?
Nicholas Hailstrom would be next.
All right, calling a case of the people of State of Michigan versus Nicholas Hailston, file 21-0707 SD. Would the prosecutor please identify themselves for the record?
Thank you, Patrick Swinsky for the people.
All right, sir, if you would please identify yourself for the record. Mr. Hailston?
Oh, nah, Nicholas Hailston.
All right, Mr. Hailston, we set our court dates on specific time slots so that I can know without opening the file what probably has happened. When we use an 8:15 time slot, that means someone says, well, I'll represent myself. But if I use a 9 o'clock time slot, which is where yours at, they must have told me at some point in time they're going to get a lawyer. Doesn't look like you got a lawyer. Did you change your mind?
I did change my mind, Your Honor. I was advised. Oh, sorry.
Are you planning on representing yourself then?
Yes, at the time, Your Honor, at the arraignment, I was told that I had been notified by Joe Amend that there was an agreement going to be where my charges and plea would be dropped to impaired. So then when I had initially told at the arraignment that I was going to be getting an attorney, I had changed my mind after that.
Okay, so Mr. Swinski, is there an offer in the file for Mr. Hailstone to consider?
There is. He's accurate. Mr. Raymond did put in an offer for an impaired with a dismissal. So it'd be an added count 3 impaired, dismissal count 1 and count 2.
Okay, so Hailstone, I am guessing at this point in time you wish to accept the offer. Is that correct?
Yes, Your Honor.
If you would please raise your right hand where I can see it. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth? So help you God.
Yes, Your Honor.
Put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, Your Honor.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, Your Honor.
If you enter this plea, you would be waiving the right to a trial. You could have had a trial by jury, or if you and the prosecutor agreed, you could have had a bench trial, but there'll be no trial at all. Do you understand that?
Yes, Your Honor.
If you enter this plea, you would be waiving the right to the assistance of an attorney, whether you hired one or I appointed one for you if you qualified. Do you understand that?
Yes, Your Honor.
You'd be waiving the right to remain silent and not have your silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
And you'd be waiving the right to confront your accusers, to call witnesses, and to testify. Do you understand that?
Yes, Your Honor.
If you understanding your pleas and waiving them are different, are you planning on waiving those rights in order to enter this plea?
Yes, Your Honor.
As you would know that there's only two charges right now, so we're going to pretend that there's an added count 3 of operating while visibly impaired. The term visibly impaired is the same as impaired driving. It's the same as if I called you Nicholas or Nick. One is a shortcut and a nickname, and the other, I guess literally in your case, but one is a shortcut name and the other one is a true name. So the visibly impaired is the true name. It's the longer name, legal name. How do you plead to added count 3 of operating while visibly impaired? Do you plead guilty, not guilty, or stand mute?
Guilty, Your Honor.
On or about May 25th of this year, were you operating a motor vehicle on North Saginaw Road in the city and county of Midland?
Yes, Your Honor.
Prior to driving that day, had you consumed alcoholic beverages?
Yes, Your Honor.
Looks like there was a data master test at the jail. Could I use that as part of my analysis to determine if you were impaired or not? It looks like 0.17 and 0.18.
Yes, Your Honor.
Okay. Mr. Swinski, if I do that, have I complied with the court rule and had an adequate factual basis?
Yes, you have, Your Honor.
I believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter as count 3, operating while visibly impaired. Counts 1 and 2, operating with a high BAC, that's count 1. Count 2, operating while intoxicated, will be dismissed. Let me take a look and see. Looks like you've been compliant with pretrial services. I am going to set this over for a pre-sentence investigation. I don't have recommendations for sentencing here on the bench, so I need a date and time for sentencing. Teresa, do we have a date and time?
August 23rd at 9 a.m.
August 23rd at 9 a.m. will be by Zoom, sir. Make sure you're following up. It looks like you're doing everything that you have been required to do. So if you continue doing that, better you do. Obviously, the worse you do, the worse you do. So you can, it's in your hands as to how well you do at sentencing. All right, anything further we need to address on the record, Mr. Swinski, in this case?
No, Your Honor. I will state there was not a crash. There's no restitution for the record.
Okay, I appreciate that. Thank you. We'll be adjourned until August 23rd at 9 a.m. Thank you. We're all set. Thank you.
Your Honor, I have an ACT team in the waiting room. I'm going to bring them in.
That'd be Mr. Zhang. I'm certain of that.
Okay. Mr. Burton, are you covering for anyone today, or are you representing only your clients?
No, I'm covering Mr. Zhang for Mr. Duke.
Okay. Then let's call that case. Calling case of the people of the state of Michigan versus Charles Frank Zhang. This is file 21-0138SM. Counsel, identify yourselves for the record, please.
Thank you. Patrick Swinsky for the people.
Leland Burton for Daniel Duke for Charles Zhang.
All right. May I address Mr. Zhang regarding your representation?
Yes, Your Honor.
Mr. Zhang, good morning.
Good morning.
Mr. Duke is your attorney, but he is unable to be here today. But Mr. Burton is here, and he wants to help you. Are you all right with him being your attorney today?
Yes, sir.
Okay.
Yes, Your Honor.
Mr. Burton, have you had an opportunity to talk with Mr. Zhang, or do you need to meet with him in a breakout room?
I need to meet with him, Your Honor. I've never spoken with Mr. Zhang.
Okay. It looks like there's a bond violation as well. Do you know the crux of that, or would you like me to see if I can pull it up for you?
I read through an failure to appear pre-sentence interview.
Okay. All right. If you'd like to meet with him, we will
Your Honor,
bring you back. Yes.
If I could just go over the issue real quick so Mr. Burton's aware. Mr. Zhang had pled guilty with the expectation he would get the deferral. Unfortunately, as Ms. Branson discovered, he's probably not eligible for it because that'd be up to the court. Ultimately, it appears he has an out-of-state conviction from California from 2009. That's assaultive in nature. So I guess a decision has to be made whether he'd like to withdraw his plea or accept it as it stands, with the possibility that he wouldn't be eligible. I believe that's correct, Your Honor.
Okay. That does look to be. Ms. Branson, good morning.
Good morning, Your Honor.
As part of the pre-sentence investigation, you were assigned to Mr. Zhang's case.
Yes, Your Honor.
You found a conviction out of California that would prohibit him from receiving the deferral. Is that correct?
Your Honor, I did. I brought it to Mr. Swinsky's attention just to see if that would prohibit him from being eligible.
Okay. Mr. Swinsky, you believe that the conviction would make him ineligible. Is that correct?
It's a felony assault case, Your Honor, so yes.
All right. All right, Mr. Burton, if you've got a flavor for the situation, I will place you and Mr. Zhang in a breakout room.
Thank you.
Thank you. Do you have anyone else we could address? Looks like Mr. Hodges is located or is incarcerated. Is that correct?
That's correct. Mr. Duke is his attorney, so I'm not sure if Mr. Burton is handling that or not. And the person in the waiting room is Tyler Holly, and he's represented by Mr. Slepp, who I don't see in the waiting room yet.
Grants, are you covering the Hodges case?
I am covering all 5 of the cases, Your Honor.
Okay. Do you need to meet with him in a breakout room?
If possible, Your Honor, I haven't had a chance to speak to Mr. Hodges prior to today.
All right. And you're familiar with all the different charges and what the kinds and types?
Yes, I did. I got some paperwork that Mr. Duke forwarded me from the prosecutor, so I'm up to speed.
Okay. Teresa, if we are able to bring in Mr. Hodges, he's in the Midland County Jail, so we'll have to bring him up, have him go to the
Polycom room?
Yes, Polycom.
And then Mr. Serwinski, it doesn't say it on the offer sheets, but I'm assuming because of its 5 cases, it's a package offer for all these.
Yes, and I believe Ms. Dusso was handling those. She
Okay.
She wanted to handle them all together, so I gladly allowed her to do that.
Yeah, and she's in another meeting, so I'll be taking them for her.
Okay. Yep. I just wanted to clarify if it was a package offer, or if each one was a separate offer. But
I can look real quick. 1 second.
So, would appear there's a fair amount of pitch hitting going on today.
Yep,
Busy
we're
day.
trying.
Your Honor, I'm going to bring in the Midland County Jail. I'm not sure if Mr. Hodges is quite in the room, but I'll bring them in.
All right. Thank you. If he is, he's sitting in the dark. All right, let's go back to Mr. Zhang's case. Recalling the case of the people of the state of Michigan versus Charles Frank Zhang, file 210138 SM. Mr. Swinsky is for the people. Mr. Burton is substituting for Mr. Duke for Mr. Zhang. Mr. Burton, you had an opportunity to speak with Mr. Zhang. Have you reached a decision regarding the case, or do we need to set it for another review?
No, Your Honor. My client does not wish to withdraw his plea. I spoke to him about the consequences of the California conviction, and he's very lucid today and knew what I was talking about and understood and still wishes to go forward with his plea.
Okay.
Intact.
So I see Mr. Bundy is with Mr. Zhang. Mr. Bundy, good morning again, sir.
Good morning.
Mr. Zhang apparently missed a meeting with pretrial for pre-sentence investigation. You feel like you've gotten hold of his mental health issues to the extent that he could comply now?
If he chooses to, I would say yes.
Okay.
I have a seat on the chair there till we call you up.
Ms. Branson, is Mr. Zhang assigned to you for a pre-sentence investigation?
He is, Your Honor.
Do you have a few moments now that you could ask him some base questions, or do you need to set up a different time?
Your Honor, I think this one might take a little bit of time. So I would like to reset it if that's a possibility.
Well, when would you like to reset it?
I mean, I could do it this afternoon or even later on this morning or something, but I would like to take more than just a couple of minutes.
Certainly. I just, we have Mr. Bundy with Mr. Zhang right now, so we're trying to find a time. So why don't we do this? I'll put the two of you in a breakout room to pick the time that would work. And then Mr. Bundy, you and Mr. Zhang can leave after that. Ms. Branson, you're also free to leave or rejoin whatever your caseload does for this morning.
Thank you, Your Honor.
Mr. Zhang, I want you to make sure you cooperate with Ms. Branson so we can complete this case. Do you understand?
Yes. Yes, Your
Okay.
Honor.
All we're going to do right now is just agree upon a time so that you can chat with her so she can get her information and complete her work.
Okay.
All right. So, Teresa, if you could place them both in a breakout room. And then I think Mr. Hodges, is that you, sir?
Yes, sir.
All right. So, Mr. Hodges, Mr. Duke is not here today, but Mr. Durant is filling in and wishes to represent you. He'd like to meet with you to talk about your cases first before we call your cases officially. Are you all right with Mr. Durant representing you and talking to you this morning?
Yes, sir.
Okay. And then Teresa, if you would please put Mr. Hodges and Mr. Durant in a breakout room. So you just have to, there's nothing you have to do, Mr. Hodges. Just sit tight. We'll move you there. And then when you're done, we'll move you back. Okay?
Yes, sir. Thank you.
Your Honor, I have a Dennis Newell back in the waiting room. He was in there earlier and we lost him, so I'm going to bring him in to find out who he is.
Okay. Is this Dennis Newell?
No.
Who are we speaking with?
William Brabaugh.
Okay. All right, Mr.
He is,
Brabaugh.
he is Mr. Lee.
Okay, we just have, it must be using Dennis's phone because it comes across to someone else. So we'll let you wait till we have Mr. Lee with us, and then we'll put you back in the waiting room.
All right,
Thank you,
thank
Mr. Briggs.
Your Honor, I
Good
can,
morning.
Tyler Holly, I see Mr. Slepp in here now.
Okay. Good morning, Mr. Slepp.
Morning, Judge.
Is that Mr. Holly who's connecting? Good morning, sir. Could you please tell me, are you Tyler Holly?
Yes, sir.
All right, calling case of the People State of Michigan versus Tyler Thomas Holly, file 210427 SD. Would the lawyers please identify themselves?
Idiot Patrick Swinsky for the people.
Ryan Slepp appearing on behalf of my client, Mr. Holly, who's present via Zoom.
Today's time and date set for a settlement conference. Mr. Slepp, have you reached a decision regarding this case?
Well, I have spoken to the prosecutor in this case. Apparently, there is another case coming down the pike, I believe. I haven't been hired on that yet. I don't know if charges have been officially charged yet. But I was hoping we could adjourn this one last time, Your Honor, so we can find out what the new charges are and possibly handle these cases together.
All right, so let me check with the prosecutor. Mr. Swinsky, are the new charges coming?
Yeah, they're felony charges, Your Honor. I believe they've already been issued. I can double check here. They would be felony assault charges, actually quite serious.
Your Honor, we do have that case entered in JIS.
Has he been arraigned?
He has not been arraigned on that.
Mr. Slepp, do you mind if I do an arraignment?
No, it appears he was arraigned on the 7th.
Let's take a look.
I apologize. You're correct. He was arraigned on July 7th.
Well, that will do. So I guess the question is, Mr. Holly. Mr. Holly, sir, are you planning on hiring Mr. Slepp, or are you requesting a court-appointed attorney, or what are your plans on the new charge?
I'm not planning on it. I'm for sure hiring Mr. Slepp. I'm coming up with the last amount of money I need to pay him off.
You are for sure planning on hiring Mr. Slepp?
Yes, sir, for sure.
Okay. All right. Let's see.
It's set for a PCC on the 27th of this month, rather.
Why don't we do this? We'll place this case on the same date and time as that case. That gives 2 weeks for Mr. Holly to come up with his funds. I think, Mr. Slepp, it looks like he's going to be on pretrial services, but it looks like he may be on 2 pretrial services. We're going to have to combine those. I think what I'll do is assign the misdemeanor case to have Mr. Holly follow up with just one. I want to make sure he's not drinking and not using drugs and following the rules, but I don't need him testing twice for both pretrial services. So, Barb, if you could please work with Mr. Alexander, whoever's assigned to Mr. Holly's case, and let's supervise through Miss Becky home as opposed to doing direct supervision of him. And then, Teresa, let's reschedule this case for the same time as probable cause conference. Mr. Holly, gives you about 2 weeks to come up with the money to be able to hire Mr. Slepp. Otherwise, you're going to have no lawyer on one case and Mr. Slepp only on the misdemeanor case.
Yes, sir.
Judge, what time is that set for on the 27th for us?
Yep, 1 o'clock.
Thank you, Judge.
It'll be by Zoom. All right, bond will be continued in both files. We'll set this over until July 27th. Thank you, Mr. Schwinski, for bringing it to my attention. July 27th at 1 o'clock. It will be adjourned on both files at this time. Thank you.
Thank you, Your Honor.
All right, thank you, Your Honor.
Thank you. We see Mr. Lee, and we had Mr. Braybaugh, are you ready to proceed in the Braybaugh case, Mr. Lee? You're muted.
Better
I know that
unmute it.
I was going to say there are many judges and many prosecutors who would like to have that power, I think.
Has he joined us, Your Honor?
He was here a little bit earlier, so let's see if we can bring him back.
He's coming back in right now, Judge.
Get somebody helping him. All right, calling the case of People State of Michigan versus William Robert Braybaugh, file 210470SD. Counsel, identify yourselves for the record.
Thank you, Patrick Swinsky for the people.
Your Honor, Richard Lee on behalf of Mr. Braybaugh.
Today's time and date set for settlement conference. Has there been any agreements reached in the case, Mr. Lee?
Yes, Your Honor, my client will be pleading guilty to visibly impaired.
Okay. Mr. Swinsky, is that the offer?
It is, Your Honor.
All right. Mr. Lee, may I address your client?
Yes, Your Honor.
Mr. Braybaugh, good morning again, sir.
Good morning.
Your attorney has negotiated a reduction in charge to visibly impaired. The term visibly impaired and impaired are the same thing. It's just, it's similar to William and Bill. Sometimes we call you Bill, sometimes we'll call you William. I don't know if anybody does, but that's kind of the similarities here. So if I call it impaired or visibly impaired, I mean the same thing. So your lawyer is recommending that you plead to the visibly impaired charge. Are you planning on following your lawyer's advice?
Yes, sir.
Okay, if you would raise your right hand and I will swear you in. You solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this charge when you really do not want to?
No.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No.
If you enter this plea, you will be waiving some rights. I'm not trying to talk you out of your decision. I just need to make sure you understand those rights. You'd be waiving the right to a trial by jury, or if you, Mr. Lee, and the prosecutor agreed, I could have listened to the case as a bench trial. There'll be no trial at all. Do you understand that?
Yes.
Mr. Lee, as your retained attorney, you'll be utilizing his services, waiving the right to represent yourself, or ask for a court-appointed attorney. Do you understand that?
Yes.
You'll be waiving the right to remain silent. Not every silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes.
You'll be waiving the right to confront your accusers, to call witnesses, and to testify. Do you understand that?
Yes.
Knowing rights and waiving them are not the same. I believe you understand those rights because you told me you did. You would have to waive these rights in order for me to take this plea. Do you waive these rights?
Yes.
How do you plead to an added count 3 of operating while visibly impaired? Do you plead guilty to that charge, not guilty, or stand mute?
Guilty.
On or about April 17th of this year, were you operating a motor vehicle on Bay City Road in the city and county of Midland?
Yes.
Prior to driving that day, had you consumed alcoholic beverages?
Yes.
Let me take a look, see if I've got the number. Mr. Lee, may I take judicial notice of the breathalyzer results of 0.18 and 0.18 as part of my analysis?
Yes, Your Honor.
If I do that, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
Mr. Swinsky, may I use the data master results?
Yes, and I agree there's a sufficient factual basis, Your Honor. Thank you.
I do too. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter as count 3, which is operating while visibly impaired. Counts 1 and 2, the high BAC, and operating while intoxicated will be dismissed. The recommendations, it looks like, is set this over for an abbreviated PSI. So we're going to set this over for sentencing date. Can we get a sentencing date in this case, Teresa?
August 23rd at 9:15.
August 23rd at 9:15. Let me take a look here. All right, so I'm going to order abbreviated PSI. Mr. Braybaugh, continue on with J&A. Get as many things you can get done before August 23rd. Probation terms are shorter, the more your stuff you get done. Probation terms are longer, the less stuff you get done. And if you do something silly or stupid, against the law, then jail's a possibility. Probably not if you act smart and follow the advice of your attorney. Do you understand?
Yes, sir.
Okay. Anything further we need to place on the record, Mr. Lee?
Nothing, Your Honor.
Mr. Swinski?
No, Your Honor. Thank you.
All right. We'll be adjourned on your case. Thank you. You may now leave the meeting, Mr. Bravo.
Thank you.
Okay. I see Mr. Durant's back with Mr. Hodges. Mr. Durant, if you had an opportunity to meet with Mr. Hodges?
Yes, I have, Your Honor, and it's my understanding we would be entering a plea at this time.
Okay, it's going to take me a second to call the cases because there's 5 of them. So it's the People State of Michigan versus David James Hodges, file 20-0917SM, 2014-17ST, 21-0439ST, 21-0824SM, 21-0857ST. Counsel, identify yourselves for the record.
Sarah Baumann on behalf of the people.
Rita Durant's unlimited appearance for Daniel Duke is the attorney of record for this case.
Okay, Mr. Durant, would you like to place the offer on the record?
Yes, Your Honor. So as far as for case 20-0917, the trespass case, that would be dismissed. 20-1417, driving while license suspended case, that would be plead as charged. Like driving while license suspended second case, that would be pled as charged. File number 21-0439, driving while license suspended second and improper plate, that would be dismissed. 21-0824, that would be pleading to the domestic violence and the dismissing the malicious destruction of property less than $200. And then file 21-0857, driving while license suspended second, would be pleading as charged, Your Honor.
All right, Ms. Baumann, did Mr. Durant get it correct?
That is correct, Your Honor.
You need about an abacus or some kind of a flow chart to get these figured out, but it sounded like he did a good job. All right. Mr. Hodges, your attorney is recommending that you follow this this offer and that you enter pleas to these cases as he's outlined them. Did that sound correct to you as he outlined them, as he explained them to you?
Yes, sir.
And knowing that Mr. Duke is not here, he will be here for the sentencing, but he's not here today. Are you agreeing to waive the right to Mr. Duke being here and accept Mr. Durant as your attorney for today's purposes to enter these pleas?
I am, Your Honor.
All right, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down now. Deb, I know that we're going to be asking you to take a lot of information down, but could you check his jail credits, please, and then let me know at some point in time? So, sir, the offers placed on the record are the only promises I know about in this case. Has anyone promised you more than this to get you to plead to these charges when you really do not want to?
No, sir.
Has anyone threatened you in any way?
No, sir.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
If you enter this plea, these pleas, you will not have a trial on any of these cases. Do you understand that?
Yes, sir.
That includes bench trial or jury trial. Do you understand that?
Yes, sir.
You'll be allowing Mr. Durant to fill in as court-appointed attorney, waiving the right to represent yourself or hire your own lawyer in each of these cases. Do you understand that?
Yes, sir.
You'll be waiving the right to remain silent, not every silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, call witnesses, and testify. Do you understand that?
Yes, sir.
Do you waive these rights?
Yes, sir.
Because we have multiple files, these rights apply to all of them as well. Do you understand that?
Yes, sir.
Okay. File 20-1417ST, that's the driving license suspended from December 6th of last year. That's the one that Mr. Durant said that you were going to be pleading as charged. How do you plead to that charge? Guilty, not guilty, or stand mute?
Guilty.
On December 6th of last year, were you driving a motor vehicle on Waldo Avenue in the city and county of Midland?
Yes, sir.
On that day, was your license suspended?
Yes, sir.
Were you convicted of driving license suspended on August 17th, 2010 here in Midland County?
Yes, sir.
And on September 21st of 2010 here in Midland County?
Yes, sir.
So this at least is your second offense. Is that correct?
Yes, sir.
Have I complied with the court rule, had an adequate factual basis in this file, Mr. Durant?
Yes, Your Honor.
Agree, Ms. Baumann?
Yes, Your Honor.
They understandingly, voluntarily, and accurately will enter the records of the court as driving license suspended, second offense. Teresa, I'm going to need a sentencing date, but I need to ask Deb if she's found the jail credits for Mr. Hodges yet.
I believe it's 27 days, Your Honor.
27 days?
Your Honor,
All
I'm
right.
showing it's booked on 6/19, which would put it at, I believe, 24 days.
He may have got credit the first time he was arrested on some of these files. So there may be a conglomerate of time. So I know he had a bunch of cases right in a row. What I'd like to do, Teresa, is schedule this to August 3rd. So plus 18. All right. So please give me a sentencing date for all of these cases, Teresa.
August 23rd at 9:30.
August 23rd at 9:30. I'll sentence them all of these cases at that time. Bond will be continued.
I
with
did
this
double check. It's 25 days.
25 days. Okay. We'll get them all straightened around.
Then, Your Honor,
Yes.
I apologize. Defendant would just like to ask to be released on a personal recognizance or cash bond prior to the sentencing date. He has a union job that he just received notice that he needs to be at, or he may risk losing, Your Honor.
I understand that, but because he's had 1, 2, 3, 4, 5 cases, and most of them this year, we couldn't stop him fast enough from committing new crimes. And so I'm denying that. What I may do is move the sentencing date up. Teresa, may we have another date that's sooner than the August 23rd date? I don't think he would show is the problem. We were having troubles getting him to appear, and he kept committing new crimes. So let's get a new date, Teresa, sooner than August 23rd.
Your Honor, we could do August 2nd, excuse me, at 9:30.
That would be good. August 2nd, 9:30 on all these files. All right. So based upon, I'm going to do it this way. So it's based upon the plea in file 2014-17, I'm going to dismiss the trespass charge in 200917 SM. And now I'm going to move on and file 210439. So we're going to move on to the domestic violence charge. In this case, this is file 210824 SM. My understanding is that Mr. Drance, your client's going to plead to the domestic violence charge, and the destruction of property is going to be dismissed. Is that correct?
That's my understanding, Your Honor.
Okay. Ms. Baumann, that is your understanding on this case?
That is correct, Your Honor.
Mr. Hodges, reminding you you're under oath and all the rights apply to this case as well. How do you plead to the domestic violence charge in count 1? Do you plead guilty, not guilty, or stand mute?
Guilty.
All right. On July 4th got the wrong one. Okay. On here we go. On June 9th of this year, were you at an address on Magruder Road in Warren Township, Midland County, Michigan?
Yes, sir.
Were you there with Tiffany Dion?
Yes, sir.
How do you know Tiffany?
She's my significant other, sir.
Okay, and on that date, the two of you get into an argument,
Yes, sir.
and at some point in time, did you hit, push, shove, or grab her hair in some way that she did not want you to?
Not exactly, sir, but I was in an intimidating way that would be considered a domestic violence. Yes, sir.
All right, so you're going more of the assault theory, meaning that you were in an argument, you were close to her, and she could have thought that you might hit her.
Yes.
And you were close enough that you could have hit her, true?
Yes, sir.
And in her mind, was it reasonable to think, based upon your arguments and your proximity and your body positioning, that she might have thought you were going to hit her?
Yes, sir.
All right. Have I complied with the court rule and had an adequate factual basis, Mr. Durant?
I believe so, Your Honor.
Do you agree, Ms. Baumann?
Yes, Your Honor.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter records to court as domestic violence. Count 1, count 2, the destruction of property will be dismissed. August 2nd will be the sentencing date. Bond will continue in that file. And finally, in file 210857ST.
Excuse me, Your Honor.
Yes.
I'm sorry, did you want a PSI on that?
No.
Thank you.
No, I do not. Thank you for asking. So I do want input from Ms. Dion, but I do not need a PSI. Mr. Hodge has been sitting in jail in the thinking chair for quite some time, and if he hasn't gotten it by August 2nd, he ain't gonna get it. So,
Very true,
at
sir.
that point in time, in this case, this is the driving license suspended second. File 210857ST. My understanding is that the defendant is going to plead as charged. Is that your understanding, Mr. Durant?
Yes, it is, Your Honor.
Okay. And is it your understanding, Ms. Baumann?
Yes, Your Honor.
Okay. So reminding you that you're still under oath and all of the rights that we talked about earlier still apply to this case. Your attorney is recommending you enter this plea as part of a bigger plea agreement. How do you plead to driving license suspended second offense on June 18th of this year? Guilty, not guilty, or stand mute?
Guilty, sir.
On or about June 18th of this year, were you driving on Main Street in the city and county of Midland?
Yes, sir.
On that day, was your license suspended?
Yes, sir.
And had you been convicted, it looks like they used different ones for this case. On December 10th, 2013 in Midland County, had you been convicted of driving license suspended on that date?
Yes, sir.
And on September 21st, 2010, were you convicted of driving license suspended on that date?
Yes, sir.
So this is at least your second. Is that true?
Yes, sir.
If I comply with the court rule and had an adequate factual basis, Mr. Durant?
Yes, Your Honor.
Have
Are
I
you cut out,
complied
Your
with-
Honor? Yes.
If the plea has been made knowingly, understandingly, voluntarily, and accurately, will enter his driving license suspended second. I will sentence him on August 2nd with all of these counts. Keep your nose clean, Mr. Hodges, and if I don't see anything new, you can anticipate being able to get out to go to do your union job on that day. But if you throw a fit and pout and act like a small child, then I got to keep you in timeout a little bit longer. Do you understand?
Yes, sir, I do.
Okay. All right. We'll be adjourned on your case, all of them. Thank you.
Thank you, sir.
Thank you, Your Honor.
Thank you, Mr. Durant. We have the Saginaw County Jail.
That would be Christopher, Your Honor.
All right. So, People of the State of Michigan versus Mr. Snyder, file 210816FY. Counsel, identify yourself for the record.
Sarah Ballman on behalf of the people.
And Mr. Hyde, this is yours.
May it please the court, Michael Hyde on behalf of Mr. Snyder.
All right. Today's time and date set for probable cause conference. We picked the 10:15 time period because Mr. Hyde also has a misdemeanor case with Mr. Schaefer, and it was able to accommodate. So is the Saginaw County Jail. So, Mr. Hyde, what is your client's preference regarding the preliminary examination?
Well, when we met last week on this, Your Honor, there had been some discussion that the prosecutor would send over to me all of the discovery materials, or at least the police reports, so I could review those and review them with my client. I've not received anything yet. So I don't know what the nature of all the charges are at this point.
Ms. Baumann, can you take a look at your notes to see why you had not sent over the discovery information to Mr. Hyde?
Yes, Your Honor, I'm looking right now. Sorry, I had to get out of all those previous cases. There's a lot going on there. So July 6th, we have here, it looks like they did, let's see.
Were they emailed?
I have discovery mailed out on 6/22 is what we have in our notes, but if you need it again, I can have them resend it.
That would have gone to the previous attorney, not to me.
Okay.
Drake was the previous attorney. I have not received anything from Mr. Drake's
Okay.
office either.
Okay, I can have them resend it to you. And
Had you filed your appearance already, had you not, Mr. Hyde?
As of last week, yes, Your Honor. It came in the same day that we had the hearing.
Okay. So do we know the timetable for your client as far as him being in Saginaw?
Well, we have a hearing tomorrow afternoon. Let me check my calendar. At 2 o'clock in front of Judge Trice. Judge Trice was kind of wanting to know what was going on here so he could craft his probation violation, an older probation violation in his courtroom. But without the stuff from Ms. Bauman's office, I haven't been able to figure that out yet. So I'm not sure what the time frame for Judge Trice is going to be, whether he's going to let Mr. Snyder out tomorrow or keep him longer. We're hoping he'll let him out tomorrow on bond. So.
Okay. Ms. Bauman, is there any way that the information could be emailed to Mr. Hyde?
yeah, I can have Alice do that right now. I was trying to look up, I don't even have in the notes his appearance, so that's likely why they didn't, you may have sent it, but usually they put it in the notes for us to see that his appearance was, filed, and then we have that, and then immediately that day that they send it. So I'm not sure why they didn't send it, but I will have Alice email it to Mr. Hyde.
Did you send it to the prosecutor's office to Mr. Hyde or just to the courts?
I believe, well, I know it was hand delivered to the courts.
Okay. So that's the triggering mechanism for the That's the triggering mechanism for the prosecutor to send the discovery. So that's probably
Yeah, we don't have your appearance. That's why you didn't get it. Because I just.
So, Deb, can we have? That's right. We'll email it over. Deb, can we have Val email over to Alice the appearance so that will trigger their discovery?
Absolutely, sir.
So let's take a look at Mr. Snyder's bond situation here. I got him on a $5,000 surety bond. So, Mr. Hyde, I suspect that after you talk with Judge Trice and you have an understanding of that case, we've left it there so that your client gets credit towards this case as well. If he modifies that bond, I'm willing to look at the bond, but it makes no sense for me to give him a PR bond. And if Judge Trice keeps him, then he loses all the time on this case as well.
Sure. And I can appreciate that. So I can communicate with the court and ask for a bond hearing after I meet with Judge Trice tomorrow afternoon.
All right. Is your client willing to waive the timing of the preliminary examination? It doesn't look like we're going to get it done within 21 days.
Yes, Your Honor.
Okay. So, Mr. Snyder, all we're doing is waiving the timing, not the actual hearing on your case. So it's just a technical question I needed to ask. We're going to set this. Teresa, can we give it? We don't have any of these next Tuesday. Can we put it for a time slot for the following Tuesday? And I think, Mr. Hyde, we just want to check the schedule. I think you had a conflict at our 1 o'clock time slot for a custody or some other matter today. So let's see if you're available 2 weeks from today at 1 o'clock.
Your Honor, that would be July 27th at 1 o'clock.
Are you available, Mr. Hyde, at July 27th at 1 o'clock?
I unfortunately, I will be driving up to Harrison at that time. I have a 3 o'clock. Oh, no, I can leave at 2. I can do a 1 o'clock. I'm sorry. Yes, I can do a 1 o'clock, Mr. Snyder.
We may have some issues with Mr. Snyder with Saginaw County Jail does a great job of interacting with us, but we're at their mercy because they have a lot of people there and they've got to deal with a lot of inmates with different counties. And so we're planning on July 27th at 1 o'clock. Your attorney, depending on when Judge Trice does, he can ask to have the bond reduced and I'll take a look at it. But right now I'm going to leave the bond in place because if I reduce the bond to a PR bond, you will get any credit towards this case. You may not need it if you're not guilty, but if you need it, then there's no sense of having you sit in the jail and being considered out of court or out of jail in our case. So the plan is right now we have a date for July 27th at 1 o'clock by Zoom. Your attorney may move that up by trying to get another date by Zoom regarding the bond. All right, we'll be adjourned on this case at this time. We'll set it for a second PCC for July 27th at 1 o'clock.
Thank you, Your Honor.
All right, we're
Your
all
Honor,
set.
I'm bringing in a phone named Adam, which perhaps is Adam Schaefer, which is another one of Mr. Hyde's clients.
Okay, so Mr. Schneider, we're all set in your case at this time, so you want to let the Saginaw County Jail know. I'd appreciate it. Give them my thanks if you would, please. Thank you.
Thank you, Your Honor.
Is this Mr. Schaefer?
Yes.
All right, calling case of the people of State of Michigan versus Adam Schaefer, file 210456 SD. Counsel, identify yourself for the record.
Sarah Ballman on behalf of the people.
May it please the court, Michael Hyde on behalf of the defendant, Adam Schaefer.
All right, today's time and date set. Looks like for bond violation as well as settlement conference. Have we reached an agreement on the case?
We have not, Your Honor. As a matter of fact, I made several attempts to speak with the prosecutor's office, but everybody was in court whenever I called, so I really wasn't able to talk with anyone. So I was wondering if it would be possible for one of the prosecutors. I saw Mr. Cherwinski here earlier. Maybe one of the prosecutors and I could speak for a short period.
All right, we'll see if we can do that. I also see we have Mr. Lee and his client, so let's find out who we have available to speak with. And I see Mr. Boucher and his client. So do we have someone that can meet with Mr. Hyde to talk about the Schaefer case?
Can, Your Honor, although I'm not sure if I can really help him because it's Ms. Duso's case, but I can see what he would like and we can discuss.
All right, we'll put you in a breakout room. Mr. Lee, is Mr. Brady with us? Well, Teresa, do we see Mr. Kelly Brady?
Ms., Your Honor.
Ms.?
Yes, she's coming in right now.
Kelly Sue. Missed the Sue part. She connects, we'll be good. All right. Are you Kelly Sue Brady?
Good morning, yes.
All right, calling case of the people, State of Michigan versus Kelly Sue Brady, file 210480 SD. Counsel, identify yourself for the record.
Thank you, Your Honor. Patrick Swinsky for the people. I can handle this quickly and then join this breakout room.
All right.
Your Honor, Richard Lee on behalf of Ms. Brady.
Based have a date set for settlement conferences and an agreement in the case, Mr. Lee.
Your Honor, we are very close to agreement. We probably need another week, maybe 2 at the most, Your Honor, and I think we'll have this case resolved.
You agree, Mr. Schwinski?
Absolutely. I spoke with Mr. Lee this morning. It's really the count 2 we're working on, but I think we'll get to an agreement.
All right. Teresa, can we give a date about 2 weeks out?
July 27th. We could do a 9:30.
All right. 22nd or 27th at 9:30.
Thank you. I'm going to join this breakout room, Your Honor.
All right. Thank you. All right, Mr. Lee, does that complete your cases?
Yes, it does, Your Honor. Thank you very much.
All right. Thank you. We'll be adjourned. Miss Brady, you're
Thank
all
you.
set to go. Looks like, let me just check here. It looks like everything's well. Continue. Yeah, go continue following what you're doing. We'll be all set for you today. Okay.
Thank you, Judge.
So, Mr. Schaefer, we're going to wait for your attorney to get back. I see Mr. Boucher with his client, though I don't know who that is. So, Mr. Boucher, if you would please unmute yourself.
Your Honor, I'm stepping in on behalf of Joseph Balada. He's under the weather. Client is Paul Cornexel.
All right. So, Mr.
Your Honor, we have a couple of unnamed phones in the waiting room. I'll bring them in.
Why don't we wait till we get Mr. Cornexel's plea and then we'll bring them in.
Okay.
If that's what's happening. So, may I speak to Mr. Cornexel?
You may, Your Honor.
Good morning,
Yes,
Mr.
sir.
Cornexel.
Good morning, sir.
Your attorney, Mr. Blada, is not feeling well, and Mr. Boucher is willing to assist you today. Are you all right with Mr. Boucher assisting you?
Yes, sir.
Okay. Mr. Boucher, what's the plans? Let me officially call the case. This is the people of the state of Michigan versus Paul Matthias Cornexel, file 210448 ST. Counsel, identify yourselves for the record, please.
May it please the court, Matthew Boucher here on behalf of Paul Cornexel, stepping in on behalf of Attorney Joseph Plata for purposes of today only.
Sarah Ballman on behalf of the people. This is actually Patrick's case, but he's in a breakout room, so I'll go ahead and take it for him.
All right, today's time and date set for status conference. My notes actually say that this was set for a plea. Is there a plea agreement in this case, Mr. Boucher, you'd like to place on the record?
Yes, Your Honor. My understanding, and I am looking at some email threads, and I did speak with between Mr. Blada and Patrick Serwinski. I did speak with Mr. Blada yesterday as well. My understanding is that the offer is pleading to and allowing dismissing the balance. My client is prepared to plead to that today. There was a ticket attached with this as well that my client paid. We just wanted to place on the record that I believe Mr. Blada and Mr. Serwinski are still working on that ticket to come to a resolution on that. But for purposes of today, we'd be pleading to and allowing dismissing the balance on this file.
All right. Does that match your notes, Ms. Baumann?
That is correct, Your Honor.
Looks like maybe Mr. Cornexel is working towards getting his driver's license back. That's good news. Has he got his license back then?
He has not, Your Honor, but he's relatively close here. It is a long process.
Been a long road, so that's good news. All right. So, Mr. Cornexel, are you planning on following your attorney's advice and pleading to the allowing?
Yes, sir.
All right. If you could raise your right hand and be sworn in. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this reduced charge when you really do not want to?
No.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
If you enter this plea, you'll be waiving the right to a trial. You could have had a trial by jury, or if you, your lawyer, and a prosecutor agreed, could have had a bench trial, but there'll be no trial at all. Do you understand that?
Yes.
You'll be waiving the right to remain silent, not every silence used against you, the right to be presumed innocent to proven guilty beyond a reasonable doubt. Do you understand this?
Yes.
Mr. Boucher will be representing you. You'll be waiving the right to object to Mr. Blada not being here. You'll be waiving the right to represent yourself or request a court-appointed attorney. Do you understand that?
Yes, sir.
And you'll be waiving the right to confront your accusers, call witnesses, and testify. Do you understand that?
Yes, sir.
Do you waive these rights?
Yes.
How do you plead to a reduced charge of count 2 of allowing another person to drive while their license was suspended? Guilty, not guilty, or stand mute?
Guilty.
The law allows me to take a factual plea based upon what you did and enter it in as a different charge. So I don't think you let somebody else drive, but you were probably driving. I don't know if you were testing a car, fixing it, or whatever, but I'll take your factual basis and we'll enter it pursuant to the plea agreement. So on February 19th, 2021, were you driving a motor vehicle on Gordonville Road?
Yes, sir.
On that day, was your license suspended?
Yes, sir.
Mr. Boucher, have I complied with the court rule and had an adequate factual basis?
You have, Your Honor.
And Ms. Baumann, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in as allowing another person to drive a license suspended. The original charge, driving license suspended second, will be dismissed. Was there any restitution I need to be concerned about in this case, Ms. Baumann?
No, Your Honor.
May I go right to sentencing then?
Yes.
All right. Mr. Boucher, anything you wish to say on behalf of your client?
Briefly, Your Honor, as the court's aware, it's been a long road for Mr. Cornexel. He has been working with another attorney here, getting his license back. It is a very arduous process, but he's relatively close. I think the plea offer made by the people is appropriate. I'd ask the court to issue minimal fines and allow him to work on getting his license back. And ultimately, he's doing everything correct, and I don't see any issues moving forward.
All right. Mr. Cornexel, anything you wish to say in your own behalf?
No, Your Honor.
Okay. Well, I know, Paul, you're doing things right now. I mean, we had these discussions before. I sent you to jail for driving a license suspended for a pretty good stretch. You even got hurt in a fight in the jail. The man I'm seeing today is a lot different than the very prideful, angry man that I saw before. And it sounds like you're doing things differently. So I'm going to do things differently. I think low fines and costs are appropriate. I'm glad to see you're trying to get your driver's license back. I'm glad you're following the rules. So it'll be the sentence of the court that you pay $75 crime victim rights fee, $50 state assessment fee. Your fines could be as high as $500. I'm going to do $125. Court costs could be as high as $475. I'm going to do $125. So I'm treating you essentially like a first time being involved in the court system. I am very pleased to see that you're taking these steps and proud of the fact that you're going to get your driver's license back. That's good news. I know you work on cars for a living. You got to test and drive them. So be careful not to get stopped for another one and wreck all this good work you've done.
Thank you.
All right. So you have 21 days to appeal the sentence, 14 days to request a court-appointed attorney to do that. Otherwise, please make your payment plan, because you won't lose your license because this is not abstracted, but you could if you don't pay or make a payment plan. Make sense?
Yep. Yes, sir.
All right. We're all set. Good luck to you, Mr. Cornexo. Very, very proud of you. Good job.
Thank you.
Thank you, Your Honor.
We'll be adjourned. I have lost track of where we're headed. I know that Mr. Schaefer's still here. We had a lot of cases today, so he's waiting on Mr. Hyde to come back. I thought I saw them come back, but it doesn't look like. We have him, and it looks like we have a number of other folks. Mr. Slepp was here for a minute. There he is. Mr. Slepp, is your client, Mr. Davis, here?
He's supposed to be. I don't see on my screen if he's here or not.
We're 3 minutes early, so maybe he's not here yet. How about
I also have a Mr. Payach.
Yeah, Payash.
And
Mr.
also
Payach here?
Heather Monville.
Okay. Do we have
Your
any-
Honor, there's a couple of unnamed phones in the waiting room.
Why don't you bring them in and name them? I'm going to go stretch my legs again.
Okay. Good morning, ma'am. Can you tell me your name, please?
Heather Monville.
Okay, Heather, I'm going to put you back in the waiting room and we'll be with you shortly, okay?
Okay, thank you. Can you hear me, sir? With the Moto G Fast phone?
Matthew, I think that's you, correct?
Brian, he's not hooked to audio.
Can you hear me, sir? With the Moto G Fast phone?
Teresa, this is Michael Hyde. Could you put me in a breakout room with Mr. Schaefer?
Sure.
Thank you. I appreciate that.
With Justin's iPhone, can you tell me your name, sir? Your last name?
Davis.
Hey, Justin, I'm going to put you back in a waiting room and we'll be with you shortly.
Okay, thank you.
The Moto G Fast phone, can you hear me? Can you hear me, sir? Can you hear me, sir?
I can hear you.
Okay, can you tell me your name, please?
Matthew Page.
Okay, Matthew, I'm going to put you back in a waiting room. We'll be with you shortly, okay?
Yes, ma'am.
Mr. Slep's 3 clients are ready and he is here. So, and Mr. Hyde and his client went back into a breakout room.
I heard that he might want to talk to me. I'm here now. Sorry about that. I was in a probate hearing.
I think Patrick handled that perhaps.
Yeah, which is fine. I just, if he for some reason wanted to talk to me, I am here.
Hey, Ataya, can you hear me?
Can you hear me?
Yeah, can you hear me?
Yeah, I can now. What's up?
Does Justin Davis have a PBT refusal ticket?
I don't know. City, was he in the city or county?
City.
That sounds like a James Branson problem.
Gotcha.
Let me see.
Ryan, we do not show PDT for him ticket.
I appreciate that. Thank you.
I'd take their word for it over mine because we don't always, unless they put it in the police report, basically, we don't always know.
Okay. Thank you guys. Appreciate it.
Mr. Hyde, is your client all set? He's still in the breakout room. I can bring him back in.
Oh, yeah, he was supposed to leave, so.
Okay.
Yeah, you can bring him back in. Teresa, you're inviting me to a breakout room. Do you have someone that wants to talk to me?
I do not.
Oh, okay,
Yeah,
then.
I'm getting invited too.
Okay, all right. And just say not now.
Okay, or later, yeah.
Or later, yeah. Okay. Thank you, Teresa.
Mr. Hyde, are you there? Mr. Hyde?
Yes, yeah,
I don't quite understand your email regarding Mr. Schaefer.
okay. I'd rather not, discuss it in open court, so
Well, can somebody put us in a breakout room then?
Sure, I can do that real quick, Ataya.
Thanks.
All right. Are we ready to proceed on the Schaefer case?
We're going into a breakout room. I got an email I don't quite understand from Mr. Hyde on that.
Okay.
Your Honor,
Mr.
Mr. Slep's clients are ready to go if you'd like to proceed on his.
Okay. Let's, we got a bond violation problem with Miss Monville, so let's call the Piash case. People, State of Michigan versus Matthew Piash, file 210403 SD. Counsel, identify yourself for the record.
Thank you, Patrick Swinsky for the people.
Good morning, Your Honor. May it please the court, Ryan Slepp appearing on behalf of Mr. Payach, who's present via Zoom.
All right. May I address your client?
Yes, Your Honor.
Matthew, how do I say your last name correctly?
Pikes, Your Honor.
Peich?
Yes, Your Honor.
Okay. All right. So, Mr. Slepp, if you reached an agreement with Mr. Schwinski in this case?
I have not, Your Honor, as of yet. The issue was that Mr. Payach has been out of state with permission due to his service, military service. While he was out of state, he has contacted J&A. I believe he's set for an appointment on July 22nd. I believe that's correct. We would ask for an adjournment so that he would be able to meet with J&A and get an alcohol assessment. At that point, I believe the prosecutors and I would talk further about a possible offer.
Is that correct, Mr. Schwinski?
That's accurate. I indicated essentially I'd need to see an assessment to make an offer, and obviously the defendant had good cause to be out of the state, so I have no objection to an adjournment, Your Honor.
Mr. Peich, your attorney says that you're going to take care of the matters now. I can't adjourn this forever. Are you planning on taking the initiative and getting this done?
Roger, sir.
All right. Teresa, can we get another date for yet another settlement conference? Mr. Slepp, the next time it's going to be set for trial with settlement conference because this case has been out since March.
I understand, Your Honor.
Your Honor, how far do you want to go out?
Well, let's just give them what we were getting everybody else, about 30 days. I think you were going out to August 23rd-ish or whatever that week is. I don't know.
Your Honor, we could do August 17th at 10 a.m.
Okay. August 17th at 10 a.m.
Thank you, Your Honor.
All right. Thank you. Bond will be continued. Good luck, sir.
Thank you, Your Honor.
All right, calling now the case of the People's State of Michigan versus Justin Davis, file 210524 SD. Counsel, identify yourselves for the record.
Atia Duce on behalf of the people.
Ryan Slepp appearing on behalf of Mr. Davis, who's present via Zoom.
Excuse me, Your Honor.
Yes, Mr. Hyde.
Could I ask to be put in a breakout room with my client one more time? I think we're coming to a resolution.
Yes.
Thank you.
All right. Mr. Slepp, have you reached an agreement with the Davis in the Davis case?
I have, Your Honor. It's my understanding that if he pled to an added count 2 of driving while impaired, count 1 OWI first would be dismissed.
All right.
My client would like to accept that today.
And Ms. Dusso, is this your case?
It is, Your Honor.
Is that the offer?
Yes, Your Honor.
All right. Mr. Slepp, may I address your client?
Please, Your Honor.
Good morning, Mr. Davis.
Good morning.
Your attorney has indicated that he has secured a operating while visibly impaired. He's recommending that you accept the offer. Are you planning on following your attorney's advice?
Yes, I am.
Could you please raise your right hand where I can see it? Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, they have not, sir.
Are you under the influence of any medicine, drugs, or alcohol that's confusing you?
No, I am not, sir.
If you enter this plea, you'll be waiving some valuable rights. Those are the rights to a trial by jury, or if you, your lawyer, and the prosecutor agreed, trial by judge. There'll be no trial at all. Do you understand that?
Yes, I do.
You're waiving the right to remain silent, not have your silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, I do, sir.
Be waiving the right to request a court-appointed attorney or represent yourself because Mr. Slepp will be your attorney in this case. Do you understand that?
Yes, I do, sir.
And you'd be waiving the right to confront your accusers, call witnesses, and testify. Do you understand that?
Yes, I do.
Will you waive these rights in order for me to accept this plea?
Yes, yes, I do.
To an added count 2 of operating while visibly impaired, do you plead guilty, not guilty, or stand mute?
Guilty, sir.
On or about April 26th of this year, were you driving a motor vehicle on St. Andrews Road in the city and county of Midland?
Yes, I was.
Prior to driving that day, had you consumed some alcoholic beverages?
Yes, I did.
Mr. Slepp, may I take judicial notice of the data master results of 0.14.13 as part of my analysis?
No objection, Your Honor.
If I do that, have I complied with the court rule and had an adequate factual basis?
Yes to both, Your Honor.
Just do so. May I take the data master results as part of my analysis, judicial notice?
Yes, Your Honor.
Have I complied with the court rule and had an adequate factual basis?
Yes.
I believe I have as well. I find if the plea has been made knowingly, understandingly, voluntarily, and accurately, will enter in records of the court as count 2, operating while visibly impaired. Count 1 will be dismissed. Mr. Slepp, the pre-sentence coordinator for your client, Ms. Branson, has indicated that he's compliant with pretrial services. He got his assessment done on May the 19th of this year. 8 sessions were recommended. He's completed half of those sessions so far. He's been testing, and all the tests have been negative, 6-1, 6-6, and 6-24. He has no prior record other than an unrelated type charge in 2001 out of Saginaw. His BAC was relatively low compared to some we've seen. That he has been, that she is recommending a short-term probation of 6 months with the ability of your client getting off probation in 3 months. I'm planning on going to sentencing. Is there anything you wish to say on behalf of your client?
Judge, I would appreciate going into sentencing. Justin is 42 years old. He does work at Larkin Labs as a millwright. He's been there for 2 to 3 years, so he is gainfully employed there and has a good future. He is divorced, but does have 4 children, which he's the primary breadwinner for. And so that's a little background on Justin. But as you had mentioned, Judge, he has been doing everything we've asked him since this began. He sought my advice. He's taken all my advice. He's gotten his J&A assessment and also has been doing great. So with that in mind, Judge, I would ask for the recommendations to be entered. Thank you.
Okay. Mr. Davis, anything you wish to say on your own behalf, sir?
No, I don't, sir.
Well, the phrase actions speak louder than words probably applies to you. You've taken what your lawyer told you to do. It's helpful for your lawyer to have somebody who's done half the classes already before you even get to the plea. That's good. You messed up on this day. That's bad, but you look to do what you could to try to fix it, and that's good. The recommendations are sound. I'm going to follow them. I do need to read them into the record. So we're going to hit you a little bit in the wallet, pretty good, but the probation term is going to be relatively short based upon your good work so far. So it will be the sentence of the court that you will pay $75 crime victim rights fee, $50 state assessment fee, $300 in fines, $475 in court costs. You'll be on 6 months of reporting probation, but you are eligible for early discharge pursuant to statute after 3 months. So if you don't mess up between now and October 13th of this year, you have the right to be able to take an off probation, provided that you've complied and completed all your programming and have tested negative the entire time. So the terms of your probation are that you shall attend and complete any counseling program to which your probation agent refers you to, pay the fees and provide proof. You shall not use or possess alcoholic beverages, illegal drugs, mind-altering substances, recreational marijuana, or any derivative of marijuana for recreational purposes, which would include CBD or THC-infused products. You shall not enter any bars or places where the primary purpose is to serve alcohol. Shall not enter a place where marijuana is dispensed, grown, manufactured, or used. Shall submit to observed drug alcohol testing with no dilute, abnormal, adulterated tests as directed by probation, pay the fees. You will serve 93 days jail, credit for 1 day served, but the balance will be suspended as long as you comply with the terms. So best outcome for you is you would be discharged from probation on October the 13th. The worst thing that could happen to you is you end up going to jail because you haven't done anything you're supposed to do. So that's the range. You have 21 days to appeal the sentence, 14 days to request a court-appointed attorney to do that. We'll be adjourned on your case. I wish you well, sir. Thank you.
All right, thank you.
Thank you, Your Honor.
All right, Mr. Slepp, you ready to proceed on the Monville case?
I am, Your Honor.
Following case of the People, State of Michigan versus Heather Monville. This is file 210489SD. Counsel, identify yourselves for the record, please.
Taya Duso on behalf of the people.
Good morning, Your Honor. Attorney Ryan Slepp, representing Heather Monville, who's present via Zoom.
All right, today's time and date set both for a settlement and a bond violation. Mr. Slepp, if you had an opportunity to talk with Ms. Duso and your client and determine the course of the case.
I have, Your Honor, but this is the first I'm hearing about the bond violation, so I haven't spoken to anybody
Right.
about.
I was just going to say the same. We had talked about an offer, but it was not knowing that.
All right, let's take a look, see from Ms. Bonneville. Ms. Tidwell, good morning.
Good morning, Your Honor.
I'm reading through your notes, but could you give us the shortened version of what the bond violation is about?
Yes, Your Honor. She failed to appear for a drug test on June 12th and June 24th.
Okay. What about the July 1st one?
She has a test from June 30th that happened after I've requested this bond violation that she also missed.
Okay, so it's missing tests. She's saying she has no finances to be able to do the testing. Did you point her to any direction for any assistance?
Your Honor, the local agency that would help with funding for testing doesn't appear that she would qualify based on her claim that there's not a substance abuse issue here.
So she claims there's no substance abuse issue, which takes her from the ability of getting some financial help as a result.
Yes, Your Honor.
Okay.
I did give her the information nonetheless.
Okay. So, Mr. Slepp, it's your client not completing on testing is the issue. So, I do understand it costs money, but so do bad decisions cost money. So, at this point in time, Mr. Slepp, do you wish to meet with your client to determine what she plans to do about the case? And Ms. Duso, I don't know if that makes a difference regarding your offer or not.
Well, it does, because it was sort of prefaced on the fact that she was taking this seriously and doing what she needed to do. I was provided with her assessment and told that she had been scheduled to do her first class on the 6th, and I was unaware that she had been missing tests since prior to that.
Okay, let's take a look through the notes. Ms. Tidwell, it does look like she got her assessment done, and it indicated that this was really more of a misuse and an adjustment reaction to anxiety. Is that correct?
Yes, Your Honor. There's some concerns within the assessment noted by JNA that the defendant might be underreporting her issues with alcohol here. So she, based on her statements, she was found to meet misuse of alcohol criteria. However, a further issue should be rolled out.
So if I were to summarize that in more plain English for me, is that the assessment came out that way because she gave them the information, and there may be some concerns. There might be a bigger issue if she wasn't forthcoming and truthful in her information provided to the counselors.
Yes, Your Honor.
Okay. So, Mr. Slepp, do you want to meet with Ms. Monville to decide where you go with the case, and then Ms. Duso, or how do you wish to address the issue?
Yeah, I would certainly like to talk to Ms. Monville first, and then
All right.
At that point.
We'll put you in a breakout room with your client.
Thank you.
We'll be temporarily adjourned on this case. Well, third or fourth or fifth time may be the charm. Call the case of the People's State of Michigan versus Adam Schaefer. Counsel, please identify yourselves for the record.
Yeah, do so on behalf of the people.
Your Honor, Michael Hyde on behalf of Mr. Schaefer. And thank you for your patience this morning, Your Honor. We appreciate it very much.
You had an opportunity to talk with the prosecutors and talk with your client. Have you reached a decision regarding the case and the bond violation?
Well, Your Honor, my client wishes to plead guilty to the first count of the bond violation, or the first date of the bond violation, May 14th. He does agree that he missed dropping on that day. Explanation is he just completely zoned past it and forgot to do it.
Okay.
And so that we would like to plead guilty to. The second date, the second date is he did go to the facility to attempt to drop. He got there about 10 or 15 minutes before they closed. He was unable to produce a sample, and they were unwilling to stay later to accommodate him. So, but he did go. He did present himself.
And what about the underlying charges?
The plea agreement, as I understand it, is to plead guilty to the first count of OWI second, and the prosecutor will drop the open intox.
Are you recommending your client accept that?
Yes.
Okay, so let's go ahead and take the plea, and then I'll talk to Ms. Hoffman what she thinks about going forward, what we need to do as far as testing. Ms. Dusso, is the offer then plead to count 1, dismiss count 2?
It is, Your Honor. And there's also
Right.
a $271 restitution request for Michigan State Police for the investigation.
Okay. All right, Mr. Hyde, may I address your client regarding the plea?
You may, sir.
Mr. Schaefer, good morning, sir.
Good morning.
Your attorney is recommending that you enter a plea to operating while intoxicated second offense and have the open intox dismissed. I'm going to set this over for some sentencing at a later date, which will also then, you'll know before the sentencing what the recommendations are, as well as cost and restitutions.
Okay.
Amounts. Are you planning on following your attorney's advice?
Yes, Your Honor.
If you would, please raise your right hand where I can see it. Do you solemnly swear or affirm testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Put your hand down now. Has anyone promised you anything more than what we've talked about on the record, or threatened you in any way to get you to plead to this charge when you really do not want to?
No, Your Honor.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, Your Honor.
If you enter this plea, you'll be waiving the right to a trial. You could have had a trial by jury, or if you, Mr. Hyde, and the prosecutor agreed, I could have listened to the case as a bench trial, but there'll be no trial at all. Do you understand that?
Yes, Your Honor.
These are the rights you'll be waiving if you enter this plea. The right to request a court-appointed attorney or represent yourself, the right to remain silent, not to silence used against you, the right to be presumed innocent until proven guilty beyond reasonable doubt, and the right to confront your accusers, call witnesses, and testify. Do you understand each of these rights?
Yes, Your Honor.
Do you waive these rights in order to accept this offer?
Yes, Your Honor.
All right, then. How do you plead to count 1 of operating while intoxicated second offense? Do you plead guilty, not guilty, or stand mute?
Guilty.
On February 18th of this year, were you operating a motor vehicle on Monroe Road, Larkin Township, Midland County, Michigan?
Yes, Your Honor.
Had you consumed alcoholic beverages prior to driving that day?
Yes, Your Honor.
Let's do so. Is there a data master result or a blood draw that I can use as part of the analysis?
Yeah, the blood draw was 0.345.
0.145?
345.
345. All right. 0.1345. Mr. Hyde, may I
Just-
use that?
Just 0.345.
You were breaking up on us. So 0.345 is very intoxicated.
Yes.
Okay. All right. And Mr. Schaefer, had you been convicted once before on May 16th in, looks like Bay County, for drinking and driving offense?
Yes, Your Honor.
Mr. Hyde, may I take judicial of the blood results of 0.345? And if I do that, I would court rule and have an adequate factual basis.
You broke up, Your Honor, but I do believe you asked if you could accept the 0.345 and you had a factual basis. Is that correct?
That is correct.
Okay. Yes, Your Honor, you may.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in records of the court as count 1, operating while intoxicated second offense. Count 2, open intox in the vehicle, will be dismissed. I'm going to set this over for a pre-sentence investigation. Sentencing date and time, Teresa?
Your Honor, August 23rd at 9 a.m.
August 23rd at 9 a.m. Ms. Hoffman, good morning.
Good morning, Your Honor.
Do you have recommendations, since Mr. Schaefer said that he missed the one, just flat out missed it, and his second time he was unable to produce a sample? Do you have recommendations of what I should do for the bond terms going forward?
Yes, Your Honor. I was unaware that he appeared on the 14th. I didn't have any knowledge of that. I just showed missed test from that date. But either way, he did not provide a sample. So you have the 2 missed tests since our last or the initial show cause hearing for this violation on the 22nd. He did test on June 24th and again on July 9th. I'm still waiting for the results from the 9th. My concern, in addition to the 2 missed tests and wanting to closely supervise him, given his blood alcohol content in this case, as well as his prior conviction from 2016 for a similar offense involving drinking and driving. My other issue, Your Honor, is in reviewing his test results in regards to THC on June 1st. From June 1st to June 24th test, his THC level has doubled. So I don't have the results from July 9th yet, but I do have a concern for continued use of marijuana as well. So initially my recommendation on the 22nd, prior to receiving the June 24th results, was going to be to switch him over to SoberLink. Perhaps that'd be a more efficient way to monitor for the alcohol use, but I am still concerned with the marijuana as well. So I would leave it to Your Honor's discretion at this point. I don't know if when he's showing up for the test, it's effective. He's on a high testing frequency. So as long as he's showing up, we should be able to see that if he is or isn't staying sober and complying with his terms. If he's not showing up, obviously that'd be a further violation. So I don't know if you'd want me to take these into consideration with my recommendations and keep an eye on it between now and sentencing. Or if he needs a wake-up call and some jail time, I would leave it to Your Honor's discretion. I don't know as though the SoberLink would be any more effective, like I said, as long as he is showing up for the testing. If that's no longer going to be an issue, it should be sufficient to monitor any substance use.
All right. Mr. Schaefer, do you have a medical marijuana card?
I do not, no.
I don't want you switching what substances you're abusing. 0.345 is close to blood alcohol poisoning.
Yes.
So clearly you've got some things you got to address. In a really short period of time, you're racking up a lot of criminal convictions. And I have to think that maybe there's some mental health concerns you need to address more than just like substances. So I'm going to keep you on that, not put you on the SoberLink. It costs more money, plus you have to constantly keep blowing into it as long as you're producing samples. The issue, though, is you're going to leave me a little choice as to what to do at sentencing. You've probably watched enough of these while you were going in and out of breakout rooms. You saw people who do better with their testing and follow up, they do better. The people who do worse, they do worse. Right now, you're kind of on the worst end. You've got more time. You got 6 weeks to kind of show. And Mr. Hyde, Mr. Hyde's got to try to come up with some things to say good about you. And obviously, there's good to say about just about everybody, but he would rather have it about how well you're doing in your treatment as opposed to, he's a smart guy. His mom loves him. I mean, when I start hearing those things, then I realize the lawyers can only talk about the things that they know as opposed to things that will be helpful. So it's best for you to arm your attorney with really good things to say about you from third parties. Because if I hear from J&A, you're doing great, that's the easiest thing in the world to do for a defense attorney. You just turn it over to the J&A people and they become your advocates, but they also will be the first to tell me you're not doing well. So let's shape it up. Your future is in your hands. But I could take it away on August 23rd if you decide you don't want your future without depressants and drugs.
Oh yeah, no, I have a family and a full-time job. I really want to keep all that. So yeah.
I would hope that motivates you enough for that, but you may want to check the other side. It may be a health issue that you've not addressed. When someone reaches that level of intoxication, there's usually something else going on. People don't. You have to live almost at being double drunk in order to function. So let's clean that up and see you on August the 23rd.
Thank you, Your Honor.
Thank you. Mr. Hyde?
Thank you, Your Honor.
All right, we're all set then.
Thank you.
Thank you. So, Deb, it was an admission to the bond violation. We just modified the bond.
Thank you.
So I think we are back with Mr. Slepp is still talking with Ms. Monville, it looks like. Now I see Mr. Garsky's symbol, and there's Mr. Garsky. How about that? Call his name and he pops up. Let's call the case of the People State of Michigan versus Dean Matthew Kaufman, file 210671 SM. Council, identify yourselves for the record.
Thank you, Patrick Swinsky for the people.
Marcus Garrison, Your Honor, with and on behalf of Mr. Kaufman.
Mr. Kaufman with us, or is that him popping in right now?
He should be on the Zoom.
Okay, he may be having troubles connecting to the audio. Teresa, can we put up the note? I see him panicking just a little minute. So if he doesn't get it right away, we can.
I think we got it, Your Honor.
Okay. Mr. Kaufman?
Yes, sir.
All right, you got it set. All right. All right, today's time and date set. I show Mr. Garski, this is regarding a plea. Is there a plea agreement you wish placed on the record?
Yes, Your Honor. It's my understanding that the people would offer a delayed sentence to Mr. Kaufman. The spirit of the delay, because there was a little bit of a delay in terms of processing this, was that the delay would be able to be completed before hunting season so that he could still hunt, but he would still agree to pay the restitution for the animal, which would be set at $1,000.
Is that correct, Mr. Swinsky?
It is, generally I do a 6-month delay on this, but I'd agree to a 3-month. It was simply just due to our inability to get it processed quickly, just simply due to workload. So I'm taking that into consideration and putting the plea together, Your Honor.
Okay, so is this a baiting?
Yes.
Or taking an animal out? Oh, so it's a baiting situation. All right. Mr. Garski, may I address your client regarding the plea?
Yes, Your Honor.
All right, Mr. Kaufman, good morning again, sir.
Good morning, Your Honor.
Every job and occupation has tools they use. Ours is no different than any other. What do you do for a living?
I'm retired.
What did you used to do?
I'm a retired police officer.
Okay, well, then this is the tool we're going to use is the delay of sentence. Delay of sentence ends up being a conviction. So you'll have a conviction on your record for 3 months, and if you are successful, then the conviction goes away. So your attorney has indicated that his recommendation is for you to accept this plea. Are you planning on following his advice?
Yes, sir.
Okay, could you raise your right hand where I can see it? Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, Your Honor.
Right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, Your Honor.
If you enter this plea, you'll be waiving the right to a trial by jury, or if you, your lawyer, and the prosecutor agree by judge, you'll be waiving the right to represent yourself or ask for a court-appointed attorney. You'll be waiving the right to remain silent, not ever silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, call witnesses, and testify. Do you understand each of these rights?
Yes, Your Honor.
Waive these rights to accept this offer.
Yes.
How do you plead to illegally baiting a deer? Do you plead guilty, not guilty, or stand mute?
Guilty.
On or about November the 19th, were you hunting in Ingersoll Township, Midland County, Michigan?
Yes, sir.
Did you place some bait out there to draw in your deer or other animals?
I did, sir. Specifically apples.
Apples, and you knew that you shouldn't have done that.
Yes, sir.
All right. Have I complied with the court rule and had an adequate factual basis, Mr. Garski?
Yes, Your Honor.
And do you agree, Mr. Shawinski?
Yes, I do.
Okay. And it sounds like, for restitution purposes, sounds like your apples were successful. You actually took an animal who came into your bait pile. Is that true?
Yes, Your Honor.
Okay. All right. Anything else we need to consider before I sentence Mr. Kaufman other than the $1,000 for restitution?
No, Your Honor. He's obviously got no record. He admitted to his mistake. I think the officer actually came in contact with him. He was compliant with the investigation. This happened back in November of 2020, so almost a year ago now. So we just asked for the 3-month delay. Obviously, minimal fines given the $1,000 restitution.
All right. Anything, Mr. Swinski from the people?
No, I agree with Mr. Garsky. He's very cooperative. Obviously, the DNR is very much encouraging us to prosecute these crimes. I would also obviously say there's no objection on reporting probation. Really, it's just a couple months to make sure, he understands that it's the law and he can move on from there.
Okay. Anything on your own behalf, Mr. Kaufman?
No, Your Honor.
All right. I'm going to sentence you to $1,000 in restitution. You pay that to the district court, and then we will forward it to the Michigan DNR. You'll be $75 crime victim rights fee, $50 state assessment fee, and let's take a look here. There is a minimum fine of $200 nor more than $1,000. In this case, because of the $1,000 restitution, I will send you to $200 and $200 for oversight. You'll be on 3 months of non-reporting probation. The terms of your probation are don't violate the law. So if you
Yes,
stick
sir.
with your non-criminal record at the end of 3 months, the case will be dismissed and you'll be back to the same status you were before. Anything more we need to place on the record, Mr. Garsky?
None for today, Your Honor.
Mr. Swinski?
No, Your Honor. Thank you.
All right. Thank you.
Your
Mr.
Honor.
Kaufman? Yes.
I'm sorry, just for my clarification, $75 crime victim fee, $50 state assessment fee, and $200 in fine with the $1,000 DNR restitution.
$100 in court costs.
Okay, and we also need a $10 conservation fee.
Okay, that's the $10 conservation fee as well. Will be you, Mr. Kaufman. You have 21 days to appeal the sentence, 14 days to request a court-appointed attorney. Otherwise, we'll be adjourned on your case. Thank you.
Thank you.
Free to go.
You can log off, Dean. If you have any questions, just give me a call, all right?
Okay, I will. Thanks.
All right. Calling case of People State of Michigan versus Christopher Rowe, file 21-0479 SD. Counsel, identify yourself for the record.
Yeah, do so on behalf of the people.
Marcus Garsky on behalf of Mr. Rowe.
Today's time and date set for settlement conference. Has there been an agreement reached in the case, Mr. Garsky?
Your Honor, it's my understanding that there hasn't been yet. We had a little hiccup at the beginning of this case, and I believe the people wanted to make sure he was doing well before they made the offer. I don't know if people are there at this point or if they would like to continue on. It's my understanding he's been doing well, so I've just switched him over to the scram.
That is correct, and I guess, given that we've had one pop up with violations that we didn't know about this morning, if the court could just confirm that there have been no further, there was looks like a positive SoberLink test we dealt with back in June. So I just want to make sure there was no other bond issues between then and now.
Certainly. So according to Ms. Tidwell, since the violation for the SoberLink test, there have been no additional positive readings for alcohol. Scram tether was installed on July the 8th. The evaluation was completed at J&A. The initial determination is that the assessment reached a conclusion of mild alcohol use disorder, rule out moderate based upon continued drinking after bond. There's 8 individual sessions recommended. He has started the sessions, and there was a recommendation, depending on his plea, that for 12 months of reporting probation with the statutory requirement that he is eligible after 6 months, and no additional jail. The standard bond terms would be applied depending on the outcome. The outcome, whether or not they're the impaired or the OWI, it makes a difference on the fines because the statutory requirements are different. But there is a recommendation to go right to sentencing from the bench, and that he has done well since the probation violation.
Given that, I would be satisfied. I'd offer him to plead to the impaired. There is a $20 restitution request for the blood draw.
Is there any for the mailbox? There was a note here.
We've attempted to make contact with the owner of the mailbox, and I don't believe we've ever heard back from him. We left him a couple of messages.
I was going to say, under the statute, you'd be able to raise the issue at some point in time during the probation. All right, Mr. Slepp, is it your recommendation that excuse me, it's Mr. Garsky's client. I looked up to the upper right-hand corner and it was Mr. Slepp. So Mr. Garsky, is it your recommendation your client entered the plea?
Your Honor, we would have to discuss that. So I don't know if the court wants to put us in a breakout room, or if, given that we don't know the issue on restitution yet, if the court wants to reset this, that's fine too. I'd leave it to the court's discretion.
I'll put you in a breakout room because it looks like they've reached out a couple of times already and have not. And the Crime Victim Rights Act says if a person comes in later, they can always request it. Looks like it's a mailbox, and so it's not a major structure. A lot of times we don't see people requesting restitution. So I would be ordering no restitution at this point in time. So if you'd like to meet with your client in the breakout room, we'll put you there, and then you can make the decision as what your client would.
Yeah, if you could, Judge, that'd be appreciated.
All right, I won't, but Teresa will. So Teresa, if you would please put Mr. Garsky and Mr. Rowe in a breakout room.
Sure.
And I think we're back then to Ms. Monville. Mr. Slepp, welcome back, sir. Are you ready to proceed on the Monville case?
I'm ready to proceed.
Recalling the case of the People State of Michigan versus Heather Monville, file 210489 SD. Counsel, identify yourselves for the record.
I tell you, I do something on behalf of the people.
Ryan Slepp appearing on behalf of Ms. Monville, who's present.
Okay, Mr. Slepp, you had an opportunity to speak with your client and make a determination regarding the bond violation as well as the settlement conference.
I have, Your Honor. I have spoke to her. Since this is the first time I'm hearing of the potential violation, and she also tells me that she has some documents that she would like me to review, I would ask to set this for a hearing if we could.
Okay. Ms. Tidwell, are you ready to proceed with the hearing?
Yes, Your Honor, I could do that.
Judge, I was wondering if we could have it on a different day so I could see the documents that she has.
She doesn't have them with her now?
I think she held them up on the.
All right, we'll set it out then for Teresa, a couple of weeks. Let's do so in this case. It says that there's an allegation regarding the defendant hit a street sign. Do we have any restitution amounts for Mr. Slepp and his client to consider as well?
MDOT has indicated they're not seeking restitution.
No restitution for the sign. Okay. All right. Do we have the date, Teresa?
Your Honor, you wanted to go out about 2 weeks?
Yes.
Okay.
Well, I wanted to do it right now, but Mr. Slepp brings a good point up. So he needs an opportunity to see his client's documents. So I will settle for the 2 weeks.
Okay, we can do July 26th at 1:45.
Your Honor, I'm out that day if it matters any.
Can you give your recommendations to one of the other agents?
Certainly.
It does matter. We care a lot about what you have to say, but I think we could probably get in it through another agent.
Yes, sir.
Mr. Slepp, are you available?
I am. July 26th at 1:45.
Let's do so. Could we have someone from the prosecutor's office available?
We can, however, I guess, I'm not sure. I mean, I know that another agent can probably read Ms. Tidwell's notes, but I don't know exactly what the issue and contention here is, but it seems that there.
2 tests.
Okay.
It says she didn't have money to pay for them. That's what my understanding was.
Okay, there's some indication. Ms. Tidwell has sent me some information regarding sort of the background of those missing tests, and it sounds like there was conversation and documents exchanged between her and Ms. Monville, and basically
So
two
a little
different
more-
stories.
You're saying a little more complex. Maybe we need to set it out a third week so that.
I just don't want to saddle somebody else to try to answer for a conversation they didn't have.
Okay. Mr. Slepp, any objection to waiting the third week?
No objection. I think that's a great idea, actually.
All
Because
right, Ms. Tidwell, are you back the following week?
I am double checking, Your Honor. I am here on the 2nd.
Okay. Do we have a time slot on the 2nd that we can use, Teresa?
Your Honor, we could do 2 o'clock.
2 o'clock on the 2nd? Does that work for you, Ms. Dusso?
Yes, as far as I know.
Ms. Tidwell?
Yes, Your Honor.
Mr. Slepp?
Yes, Your Honor.
All right, presume Ms. Monville will be available as well. So we will adjourn until till that time. Thank you very much.
Thank you, Your Honor.
Thank you. So I see people move around when they leave. So I see Mr. Roback, but I do not see Mr. Garsky yet. Ms. Monville, you're free to leave. If you can't figure it out, it's okay. We can, looks like she figured it out. Katrina, do we have, excuse me, this is the first time I did that this morning. Teresa, do we have Mr. Garsky in a breakout room with someone else right now?
Your Honor, he is in a breakout room, but it appears he's the only one in there.
Maybe he needs some thinking time. Let's see Mr. Rose back. Let's see, can you pop into that breakout room and invite Mr. Garsky back to us?
Sure, I'll just close the room. He's the only one in a room.
All right. We have the Moto G Power. So if the person from Moto G Power, please unmute yourself and let us know who you are. You're going to have to hit *6 or *7. If it's a cell phone, you will have to hit spacebar if it's a computer. Or, I guess, just leave. I think they're gone. Mr. Garsky and his client are both gone.
I'm being invited to join a breakout room 6. I assume that's not.
I would just not. We'll see if we can get everybody back.
Yeah, Mr. Garsky and Mr. Rowe are back in a breakout room now.
Well, close it out. Let's bring them back here. See if we can get this horse to barn. Now and again, my hayseed pops up. Mr. Rose back.
It kicked me out.
All right, Mr. Garsky's back. Now he's gone. Now he's back. All right, so hang on just a second. The Moto G Power. Can you tell me your name? We're struggling hearing you. Well, let's put him on mute and then we'll handle the Rowe case. Recalling case of the people of the state of Michigan versus Christopher Rowe, file 210479 SD. Mr. Garsky is here for his client. Ms. Dusso is here for the people. Mr. Garsky, have you had an opportunity to talk with your client regarding the offer?
We were, Judge, then we got kicked out. So I guess I just asked him if he's got any more questions about accepting it. If not, then we can proceed.
I'm good.
Okay. He's going to accept the offer?
Yes, Your Honor.
All right, Ms. Dusso, it is impaired. Is that correct?
Yes, Your Honor. With the $20.
All right, Mr. Rowe, you wish to plead to the visibly impaired?
Right.
If you raise your right hand, I'll swear you in. Do you solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, self you got?
I do.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No.
Are you under the influence of any medicine, drugs, or alcohol that's confusing you?
No.
If you enter this plea, you'll be waiving the right to a trial, either by jury or by judge. You'll be waiving the right to represent yourself or request a court-appointed attorney, the right to remain silent, not have your silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, call witnesses, and to testify. Do you understand each of these rights?
I do.
Be waiving them if you enter this plea. Do you waive these rights?
I do.
How then do you plead to an added count 2 of operating while visibly impaired? Do you plead guilty, not guilty, or stand mute?
Marcus, you want
to? Chris, if you're taking the deal, you'd be pleading guilty to the.
Okay, yeah, I plead.
Dismiss
Correct.
the regular drunk driving.
Okay, I plead guilty. Just wanted to say the right thing here.
on or about February 10th, were you driving a motor vehicle on North Hicks Road in Lincoln Township, Midland County, Michigan?
Was.
Prior to driving, had you consumed alcoholic beverages?
I did.
Mr. Garsky, may I take judicial notice of the blood test results? It looks like a 0.157 in my analysis.
That is correct, Your Honor, and no objection to taking those.
If I do that, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
Ms. Duso, any objection to my taking judicial notice of the blood test results?
No objection.
Have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in records of the court as count 2, operating while visibly impaired. Count 1 will be dismissed, which is operating while intoxicated. Mr. Garsky, the recommendations from my pretrial services coordinator is what I had indicated. They're recommending because of the change in the law, we have to order, we always try to order enough time for a person to complete their test, but because now we have to give a halfway point, the probation terms are longer, with the halfway point being half. So the recommendation is a 12-month reporting probation eligibility after 6 months with standard bond terms and fines and costs. Do you are ready to proceed to sentencing?
Yes, Your Honor.
Elocution on behalf of your client.
Your Honor, this is his first offense, looks like, of any kind. He travels throughout the country for work, so we just ask that in terms of his probation be allowed to leave the state for work purposes. He has now been on the scram tether. There's been no problems with the scram tether. I would ask the scram tether cease while he's on probation, and that he comply with all terms that whatever the court feels are necessary. I believe he's already set up with classes, and he will continue those and complete everything that the court requires of him.
So you're asking for him not to be tested at all while he's on probation because he's out of state?
I would ask that just some sort of random testing be sent in versus the scram tether. Obviously,
if he's leaving, if he's driving all over the United States or flying over the United States, how are we going to know where he's at? So he's going to have to find a place each time. I mean, we could go from scram tether to SoberLink, but I think it's probably not in his best interest to just try to figure out a place where he's at. He flies in late and then has to find a place to drop.
I guess just the scram tether can create also obviously issues with the travel too, having that on your leg and all that. So that's why we would ask for the random. Obviously, we leave it to the discretion of the court on that, though.
Okay. All right, Mr. Rowe, anything you wish to say on your own behalf?
Nope.
Let's do so. Any input from the people?
Your Honor, we just asked that the $20 for the blood draw fee be ordered restitution to the prosecutor's office. Otherwise, I mean, this is a fairly straightforward standard OWI.
Okay. Be the sentence of the court that you pay $75 crime victim rights fee, $50 state assessment fee, $300 in fines, $475 in court costs. There'll be $20 to be owed for the blood draw fee. You'll be on 12 months reporting probation. You're eligible for early discharge after 6 months if you meet the criteria. You shall attend and complete any counseling program to which your probation agent refers you to, pay the fees and provide proof. Shall attend and complete any impact weekend. Shall attend and complete an impact weekend, pay the fees, complete any recommended follow-up. Shall not use or possess alcoholic beverages, illegal drugs, mind-altering substances, recreational marijuana, or any derivative of recreational marijuana, including CBD or THC-infused products. Shall not enter any bars or places where the primary purpose is to serve alcohol. Shall not enter any place where recreational marijuana is dispensed, grown, manufactured, or used. I want some kind of electronic monitoring, whether it's scram tether or it's the SoberLink item for the 6-month time period. Pay the fees upon completion. You submit to observed alcohol drug testing with no dilute, abnormal, adulterated tests as directed by probation. Pay the fees. Shall serve 93 days jail credit for 1 day served. Balance will be suspended if he complies with all terms. I have no objection to the defendant going out of state due to his work. Mr. Rowe, I want you to work with your probation agent, Ms. Tidwell, to figure out how it is we're going to monitor your alcohol use. 0.15 is fairly high for someone who doesn't have any prior history, although it did look like there was at least a charge from Houston from earlier. So that's one of the reasons we're taking into consideration testing needs to continue. I think it's in your best interest to have some kind of electronic, whether it's Scram or the SoberLink, because I don't know what time you arrive, but if you're only someplace in a town for a day or so, trying to find a testing place and get in and make sure you comply, I think would probably be more cumbersome than as difficult as the Scram tether is. So it doesn't have to be Scram; it can be SoberLink, but you need to work that out with Miss Tidwell.
Understood.
All right, we'll be adjourned on your case at this time. Thank you.
Thank you, Judge.
Thank you, Mr. Carson. See Mr. Durant and Mr. Durr, so we'll call the Durr case. The People State of Michigan versus Kyle Jacob Durr, file 210481SD. Counsel, identify yourself for the record.
Peter Durant on behalf of Kyle Durr, who is appearing via Zoom today.
Patrick Schwinsky for the people.
All right, today's time and date set for a plea. Is there a plea agreement you wish to place on the record, Mr. Durant?
Yes, there is, Your Honor. In exchange for dismissing count 1, defendant would plead to an added count 2, operating while visibly impaired.
Does that match your records, Mr. Schwinsky?
It does, Your Honor.
Mr. Durant, may I address your client?
Yes, Your Honor.
Mr. Durr, good morning, sir.
Good morning.
Your attorney is recommending you plead to an added count 2 of operating while visibly impaired. Are you planning on following his advice?
Yes, sir.
Would you please raise your right hand where I can see it? Do you solemnly swear or affirm testimony you're about to give is truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, Your Honor.
Are you under the influence of any medicine, drugs, or alcohol that's confusing you at the moment?
No.
If you enter this plea, you'll be waiving some rights. Those rights are the right to a trial by jury, or if you, your lawyer, and the prosecutor agree, you'll be waiving the right to a bench trial as well. Mr. Durant, are you retained or appointed?
Appointed, Your Honor.
You'll be waiving the right to hire your own attorney and the right to represent yourself. You'll be waiving the right to remain silent. Silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt, and the right to confront your accusers, call witnesses, and testify. Do you understand each of these rights?
Yes, sir.
In order for me to take this plea, you would have to waive these rights. Do you waive these rights?
Yes, Your Honor.
How do you plead to an added count 2 of
Can you hear me?
Yes. How do you plead to added count 2 of visibly impaired? Guilty, not guilty, or stand mute?
Guilty.
On April 23rd, were you driving a motor vehicle on North Saginaw Road in the city and county of Midland?
Yes,
Prior
I
to
was.
driving that day, had you consumed some alcoholic beverages?
Yes,
Mr.
sir.
Durant, may I take judicial notice of the data master results of 0.11 as part of my analysis?
Yes, Your Honor.
If I do that, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
Do you agree, Mr. Schwinsky?
Do.
I do as well. I find that the plea has been made knowingly, understandably, voluntarily, and accurately will enter records of the courts as operating while visibly impaired. That's count 2. Count 1, operating while intoxicated, will be dismissed. Mr. Durant, it looks like the recommendation for your client is standard bond terms with a 6-month initial term of incarceration, or 6-month initial term of probation with the eligibility to go off of probation after 3 months if he is compliant with and completed his terms. Are you ready to proceed to sentencing?
Yes, Your Honor.
All right. Go ahead and make allocution on behalf of your client.
Thank you, Your Honor. The recommendation, I believe, is very fair in this case. Mr. Durr has expressed that he's able to follow the court's orders while he's on bond. I don't think there'll be any issues while he's on probation. Thank you.
Mr. Durr, anything you wish to say on your own behalf?
No, sir.
Mr. Schwinsky, any input regarding sentencing?
No, Your Honor, I don't have an objection. I leave it to the court's discretion. Thank you.
Okay. Looks like Mr. Durr got evaluated at Crossroads Counseling on June the 2nd. Does not meet any DSM-5 criteria for mental health or alcohol use disorder. His audit score was on the higher end, but of the low risk category. It is recommended he attend 4 to 6 sessions of psychoeducation. Finances are a little bit of a challenge, so I think the recommendations take that into consideration. He still has THC in his system, but it's decreasing, so we want to continue seeing that. He does not have a medical marijuana card, so you cannot use, even if he thinks it's for medical purposes, because you need to have at least a medical marijuana card. So it is the sentence of this court that you will pay $75 crime victim rights fee, a $50 state assessment fee, $100 fines, $100 court costs, 6 months of reporting probation, eligible for early discharge halfway, which is 3 months, eligible for that, which would be October the 13th. If you have completed all of the terms of your probation and made reasonable efforts to pay all your fines. You shall attend and complete any counseling program to which your probation agent refers you to, pay the fees and provide proof. Shall attend and complete next available impact weekend, complete any recommended follow-up, provide proof, pay fees. Shall not use and possess alcoholic beverages, illegal drugs, mind-altering substances, recreational marijuana, or any derivative of marijuana, including CBD or THC-infused products. Shall not enter any bars or places where the primary purpose is to serve alcohol. Shall not enter any place where marijuana is dispensed, grown, manufactured, or used. Shall submit to observed alcohol drug testing with no dilute, abnormal, adulterated test as directed by probation, pay the fees. Shall not engage, well, it says shall not engage in any threatening, intimidating behavior. I think that might have been an error. I don't think there was no fight or any other charges, were there, Mr. Durance?
No, Your Honor.
Mr. Schwinsky?
There wasn't, Your Honor. I just checked.
Okay, I'm striking number 11. I have no idea. That might have just been a copy and paste error. So he shall serve 93 days jail credit for 1 day served, balance to be suspended if he complies with all the terms. Mr. Durr, you have 21 days to appeal the sentence, 14 days to request court appointed attorney to do that. Otherwise, we'll be adjourned on your case at this time. Thank you, sir.
Thank you.
Thank you, Your Honor.
Thank you. So we have Mr. Burton, and we're looking for his two clients. I see Kayla Clark may be here. You're free to go, Mr. Durr.
All right. Have a good day.
You too. Calling case of the People State of Michigan versus Kayla Marie Clark, file 210494SD. Counsel, identify yourself for the record.
Thank you, Patrick Swinsky for the people.
Leland Burton for Kayla Clark.
Today's time and date set for looks like a plea. Is that correct, Mr. Burton?
Yes, Your Honor.
All right. And is there a plea agreement you wish to place on the record?
Ms. Clark will plead guilty to count 2 and return count 1 will be dismissed. She'll be pleading the intoxicated.
All right. Mr. Swinsky, does that match your offer?
It does, Your Honor.
Mr. Burton, may I address your client?
Yes,
Good morning,
Your
Ms.
Honor.
Good morning, Ms. Clark. Can you hear me?
Yes, I can.
Your attorney is recommending that you plead guilty to count 2, which is the lower of the two, of the operating while intoxicated. The high BAC would be dismissed. Are you planning on following your attorney's advice?
Yes, Your Honor.
If you would, then please raise your right hand where I can see it. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down now. Has anyone promised you anything more than what we talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, Your Honor.
Under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
Under this plea, you'd be waiving the right to a trial. You could have had a trial by jury, or if you, Mr. Burton, and the prosecutor agreed, could have had a bench trial, but there'll be no trial at all. Do you understand that?
Yes.
You'd be waiving the right to retain your own attorney or represent yourself. Do you understand that?
Yes.
The right to remain silent, not have your silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. You'd be waiving the right to confront your accusers, call witnesses, and to testify. Do you understand these rights?
Yes, Your Honor.
Waive these rights if you want to accept this offer. Do you waive these rights?
Yes.
How do you plead to count 2, operating while intoxicated? Do you plead guilty, not guilty, or stand mute?
Guilty.
On or about March 10th of this year, were you operating a motor vehicle on Waldo Avenue in the city and county of Midland?
Yes, Your Honor.
Driving that day, had you consumed some alcoholic beverages?
Yes.
Burton, may I take judicial notice of the blood draw results of 0.194 as part of my analysis?
You may.
That have I complied with the court rule and had an adequate factual basis?
You have.
Mr. Swinsky, if I complied with the court rule and had an adequate factual basis, and do you consent to me using the blood draw?
Yes to both, Your Honor.
All right. I believe the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter requisite court as count 2, which is operating while intoxicated. Count 1, operating with a high BAC, will be dismissed. It looks as if we need to set this over for a pre-sentence investigation and sentencing. So this will be an abbreviated PSI for victim input, better recommendation of that and looking at prior criminal history. Can we get a sentencing date and time, Teresa?
Your Honor, August 23rd at 9:15.
August 23rd at 9:15. Okay, Ms. Clark, let's get on it. It looks like you've been compliant so far with pretrial services. You got your evaluation done at basis on June the 7th. Says that you would recommend benefit from outpatient therapy and possibly group. You've been attending sessions. You're on the color line. All the tests are negative so far, which is good. We'd like you to get an impact weekend done. So if you want to try to get that done before August 23rd, you'll have more stuff done before the sentencing. You understand?
Okay. Yes, Your
You're
Honor.
already good. You'll already be in good graces with your lawyer because I see the Ohio State flag up above your head, and he's an Ohio State fan or graduate. So you've already got the good graces of your lawyer. So let's make sure you keep on the positive track. All right, bond will be continued. We'll be adjourned. Thank you.
Thank you.
So, Mr. Burton, I show a plea is supposed to be for Mr. Joshua Smith. Have you had contact with Mr. Smith today?
No, Your Honor, and you issued a bench warrant yesterday for his failure to appear to show cause for failing to comply or set up pretrial services.
All right. Well, if I have done that already, he's in warrant status, and he is. So there's no reason to go any further with that. We'll be adjourned. Any further? That's Teresa. Is that it for the morning?
It is.
It looks like we finished 2 minutes before noon. We filled that morning up. All right, we're adjourned.